Janelle, has the recording begun? Janelle? Okay, great. Hello, good morning, everyone. And it is now 10:06 a.m. on August 29th, and apologies for starting the meeting a few minutes late. We're going to get started with call to order and the meeting. We will note for everyone present that this is a remote meeting, like a regular in-person meeting of the Privacy Law Group. It is recorded and will be archived on the State Bar's website. The Privacy Law Group will take items on the agenda in the order they appear on the agenda, and we will vote for any items that will be taken by roll call. Janelle, we will begin with roll call. You're also, yeah.
One moment. There will be a little echo. Choi? Davis?
Here.
Kirshenson?
Here.
Isri?
Present.
Jaworski?
Present.
Galay? Karanian?
Here.
Froelich?
Here.
Lanoy? Martinez? Rajmahan? Serrato? Lunaka?
Here.
With 9 present, we have quorum.
Janelle, it looks like Paul has joined, but he is having trouble connecting. If you can follow up with him, please. Okay. We'll move on to call for public comment. The Board of Trustees recently adopted a public comment policy that applies to all State Bar committees, including this one. Its policy statement says the State Bar of California welcomes public comment at all of its public meetings and appreciates listening to a wide range of viewpoints that reflect the diversity of California. Those public comment rules are designed to ensure that members of the public may exercise their right to be heard, as well as ensure that the State Bar is able to fulfill its obligation to conduct public business on behalf of the people of California in a timely fashion. Written public comment may be submitted to the email address on the meeting agenda. We encourage you to submit written public comments at least 24 hours prior to the start of the meeting. Written comments received less than 24 hours prior to the start of a meeting will be distributed the following business day. If you bring written materials to a meeting for distribution, they will be collected by the meeting secretary and distributed after the meeting concludes. For oral public comments, persons were encouraged to sign up to speak in advance of the meeting and will be called in the order they have signed up. Persons attending the meeting remotely will be called in the order that they appear in the attendee list. And in a moment, I'll explain how to raise your hand to tell us that you want to do that. Speakers cannot cede their time to another speaker. It does not guarantee that all who wish to speak will be able to do so to facilitate hearing from as many members as possible. We encourage you not to repeat points that were made by previous speakers. Simply say that you agree with them to allow the committee the time needed to deliberate on the important topics that it will be discussing today. We'll be limiting public comments to 3 minutes per person. As a reminder, the State Bar's anti-discrimination and anti-harassment policy says the State Bar maintains zero tolerance for unlawful harassment, discrimination, and retaliation. Employees must at all times treat all other employees, job applicants, and persons providing services to the State Bar with respect and dignity in accordance with this policy. Likewise, the State Bar will not tolerate harassment, discrimination, or retaliation against its employees, job applicants, or members of the public by any employees or by any person with whom the State Bar has a business service or a professional relationship. If you're in Zoom and want to speak, you'll need to raise your hand unless you are already on the pre-meeting sign-up list. To do so, you click on the hand icon that's at the bottom center of your Zoom window. If you're participating by telephone, you may virtually raise your hand by pressing *9. That's the star key and then the number 9. Our coordinator will call members of the public, starting with the pre-signups, then the Zoom list, followed by in-person signups in the order that they raised their hands or signed up. Staff will enable the microphones of the speakers, start the timer, and then call out when 30 seconds remain. Do we have anyone that wishes to make comments? If yes, let's go ahead. They can address any item on the agenda. They do not need to state their name or their affiliations. At the conclusion, we're going to move on to any other speakers. Janelle, at this point, I don't believe we have any planned guests.
We don't have any planned guests, but we do have a guest, commenter. I'll go ahead and allow him to speak.
Great.
Go ahead.
Hi, I'm Ray Hayden, and I hope you all can hear me well enough. I'd like to discuss. Thank you very much. I'd like to discuss a few points just to ensure that they remain at the forefront of everyone's mind. First, the California Bar has dropped the written section of the first-year law students examination because the written section failed to be indicative of success on the California General Bar exam. However, the multiple choice questions are adequate to be indicative of success for exam takers. Second, California Bar experts have stated that the written section of the exam also had a detrimental effect across all exam takers, and to state the obvious, including those who passed. Third, it appeared no one realized this when I was watching the discussions. The written section is subjectively graded, which is illogical, being that Cal Bar is seeking to make an objective assessment with subjectively graded examinations. The logic of including subjectively graded written section fails to connect. A new area, Cal Bar was successful in removing the written section of the first-year law students examination. A reminder that for the first-year exam, we had been done with those subjects of law study, and it was the expectation that we write to the level of a newly licensed lawyer. Thus, the logic is identical for the removal of the written section for the California General Bar exam as well. On the upcoming changes to the February 2025 California General Bar exam, I suggest that the written section be removed from the exam. Then also that an honestly objective and fair set of multiple choice questions are quite adequate to assess that we are more than minimally competent to enter the profession of law, and that Cal Bar continue to work to ensure that the California General Bar exam be available remotely at authorized exam centers around the world to reduce the incredible expense burden placed on many of us from locations far from California. Take note, the travel, lodging, and other expenses actually increases during the dates of the exam because they know we're coming. New area, and last one, let's not forget those who are trapped in the provisionally licensed lawyer program limbo. Those who are in the program and are still in good standing should be directly admitted to the bar because they actually are victims of a good intention at the time of the pandemic, but they've been paying a price ever since, and they should be admitted if they meet all the other requirements. I thank you very much for your time and have a wonderful meeting.
Thank you for your comments. Janelle, do we have any other speakers?
Sorry, we do not.
Okay. At this point, I would like to welcome everyone again to the meeting of the consulting group on the establishment of a legal specialization in privacy law. We're going to begin our business with the minutes. We're going to approve the last meeting, which took place on April 25th, 2024. And we're going to ask that everyone has had the time to review. And is there a motion to approve the April 25th, 2024 public meeting notes?
So moved, Unaka.
Second, Jaworski.
Thank you. We're going to vote by roll call. Janelle?
Troy? Davis?
Agreed.
Christensen?
I'll abstain. I was absent from the meeting.
Isri?
Agree.
Jaworski?
Agree.
Clay? You're on mute.
Agreed.
Thank you. Karanian,
Agreed.
Froelich,
Agreed.
Lenoy,
Agreed.
Martinez, Rajmohan, Serrato,
Agreed.
Tanaka,
Agree.
sorry, 1, 2, 3, 4, 5. With 9 agree, yays, the motion passes for the minutes.
Thanks very much. We'll now move on to business item agenda 3A. This was the review and discussion of the member research regarding the potential privacy law practice standards for certification and recertification. So just to highlight that the purpose of the assignment, and for the next few minutes, we're going to be getting the presentations from the members who research the potential privacy law practice standards that we propose for certification and recertification for the specialization of privacy law. We're going to begin by having Mariah present on her research on the tasks and the experience portion on litigation and disputes. If we can move to the next slide, please.
Thank you and good morning, everyone. Samita, Rajmohan, and myself were tasked with evaluating what amount of litigation or dispute qualifications, if any, should be required for an applicant to obtain the privacy law specialist recognition in California. The first determination or recommendation that we made, which is actually not included on the slide, is that we don't believe any litigation or dispute experience is strictly required for an applicant to be recognized as a privacy law specialist. We believe that qualified applicants may have litigation and dispute experience, but it's not a strict requirement of the certification. For those applicants who are litigators and want to rely exclusively on their litigation and dispute experience for their application, we recommend that they have both quantitative and qualitative experience, which is up on the slide. Specifically with respect to quantitative experience, we recommended that the applicant be able to demonstrate that some amount of hours of their practice has been devoted to privacy, cyber, and technology litigation. We recommended that quantitative component be either 10,000 hours of practice, we recommended that they have at least 10,000 hours of practice devoted to relevant litigation dispute experience, and they could show that in different ways. We have 2 examples of how they could show that up on the slide. The first is that, for example, they could have 5 years of practice that was 100% devoted to the relevant litigation dispute experience, and that assumes that they practice about 2,000 hours a year. Alternatively, they can have 10 years of experience, but only 50% of which has been devoted to relevant cyber, privacy, and technology litigation or dispute experience. Or, of course, some other combination. It was really that 10,000 hour threshold that we thought was important quantitatively. For purposes of the application, we recommended that the applicant be able to describe at least 3 to 5 relevant litigation or dispute cases or investigations that they've handled as sort of qualitative examples of their experience and specialization in the space. We also recommended that the applicant include a statement of purpose or a similar qualitative assessment where they explain how that experience uniquely qualifies them to be recognized as a privacy law specialist. We also wanted to recommend that the committee consider this hours requirement or some other quantitative analogous requirement for all applicants generally, and not just those relying on their litigation and dispute experience. Thank you.
Thank you, Mariah. We're going to have a discussion, and thank you very much for your research and your proposal for both you and Smita. Any of the members have any comments or questions for Mariah?
I have
I
a
have-
question.
Go ahead.
Just a quick question. With respect to the experience, the number of years, I think with respect to specific subject areas, are we planning on having that for specifically for litigation, or is the plan to have a number of years experience or hours of experience that's across the board, but then some folks might be in litigation and they'll meet that criteria through the litigation prong or the experience through the transactional prong, because I think it should be harmonized across the different experiences. So maybe that might be a topic of discussion as to what collectively we think the years of experience should be. But the years reflected here makes sense to me, you know, to the extent we want to apply it across the board. But that's the only comment I wanted to make.
I would just comment in response to that. We agree. So it was the general recommendation that there should be some quantitative component across background, whether it's litigation, whether it's regulatory, et cetera. But for litigation, we had recommended the 10,000 hours as one potential threshold.
Mhm.
And
So-
my question goes along these same lines and it's more to staff, is how does this line up with requirements, or is it applicable that it lines up with requirements for the other specialties or not?
Do you,
So it's-
Adrian or Janelle, do you have an answer, or would you like me to answer that?
Would you like to chime in as far as that goes for this?
Say that again?
Adrian, would you like to chime in?
Oh.
I think the only alignment for all those practice areas is a 5-year practice requirement. So any tasks being claimed will need to be done in the 5 years preceding submission of their application. It may be best to go through each of the different categories so that you can look at it holistically, and then you can decide like if you're going to award points, like a certain amount of points to litigation and then a certain amount of points to another area. And then applicants only need to get a minimum amount of points to qualify. Or if you want to say, like, let's say if there's 5, I don't remember how many different areas or different presentations there are, but even of those areas, applicants need to check off that they've done 3 of those or 4 of those or something.
Mm-hmm.
So I think maybe it's probably best to look at all of the different areas first. And then once you see them all together, you'll be able to decide exactly how you want the applicants to report that.
I think that's right. So as a reminder, we are going to have 4 different areas. This is the first of the 4. The first is the litigation and disputes experience. Second is going to be advisory and regulatory compliance. Third is transactional. And then 4th is incident response, data breach, and security. And I agree with the commenters and Mariah, it sounds like you were also cognizant about that too. I think at the end of this discussion, and after we have heard from all of the different member research portions, we'll decide, are we going to go to some kind of a point system as Adrian proposed, or is it good enough to have just all litigation experience, for example, right? And so I don't think we have decided that yet, if we're going to allow for partial points for maybe a little bit of litigation. So let's say you don't have 10,000 hours of litigation, but maybe you have 5,000, maybe you have 500, right? Some portion of it, would you get credit for that, versus you have to kind of go a litigation track. I don't think we've discussed that. I think we should, think about that as we hear from the other member presentations. But for now, it sounds like, just for clarification purposes, Mariah, I think what you were saying is that a specialist applicant may have 0 litigation, but to the extent that you are a litigator and want to get the litigation privacy credit. If you had 10,000 hours of practice shown in a multiple different ways, and then 5 years versus the 10 years, et cetera, that could be one way to become a specialist even if you had no other experience. Is that right? So even if you had no advisory, no regulatory, no incident response, just as a pure litigator, this would satisfy. Is that what we're hearing?
That is an accurate summary of our recommendation, and we felt that that reflects what we know about kind of legal practice, in that most of the time litigators are litigators. They don't always have the opportunity to do as much proactive regulatory compliance, although some do.
Adrian, do you have your hand up?
Yeah, I'm trying to maybe understand this 100% devoted to. So just generally for applicants to get certified, they only need to devote 25% of their practice to the area in order to qualify.
So no.
Okay.
So first of all, an applicant does not need to have any litigation and dispute experience whatsoever in order to qualify if they have one of the other 3 buckets of experience. So they don't need to show any litigation and dispute. However, for the applicant that relies exclusively on their litigation and dispute experience, we recommend that they show that they have at least 10,000 hours of practice devoted to data privacy, cyber lit, or technology lit. And we can also work through at a later time specifically what those criteria look like. So this is really the pathway for someone who is applying exclusively on their litigation and dispute experience alone.
So we might want to discuss then, Mariah, to the extent that this was meant, the 10,000 hours that you're proposing is for somebody who is exclusively relying on litigation, what portion of this could be going towards, let's say, if we end up in a point system, where we could get some credit for litigation, we might want to kind of maybe discuss that maybe after we have heard the other presentations too. Would you be open for that?
Absolutely.
Great. Adrian, you said something that I wanted to make sure that we heard it right. You said something about the 5 years preceding, because I'm seeing here that Mariah and Smita is proposing that up to 10 years of experience could be part of this application to demonstrate experience. Are you saying that largely when we have a specialist application process, that it would only look at the 5 year preceding the application? Is that what I heard? Or
yes and no. So yes, because in order to get certified, you have to have been practicing in the area for 5 years. No, and this I don't know how much thought was put into this. So you can have different requirements for initial certification versus when they recertify every 5 years. So if you look at the appellate application, it's point-based. Applicants can count experience through the lifetime of their practice, but only so many of those points can count towards the whole requirement. Does that make sense?
Yes, I think so. I think what I think Mariah and Smita were proposing is when we say 5 years of practice or 10 years of experience, I think you were talking about over the course of the lifetime, in the entire career. You were not just talking about the 5 years directly preceding the application time, right?
Correct. And we wanted to be really reflective of what we know about data privacy and cyber litigation, which is that nowadays you can have people completely devoted to this area, but historically, just because of the way it kind of emerged, right, with data breach defense and everything, it was unlikely that people would be 100% devoted. So we wanted to give them credit for kind of the lifetime of experience that they had, mindful of the fact that 10 years ago, this was probably only 30% of most people's dockets, of most litigators' dockets, excuse me.
And one thing to that point, Mariah, because I think what we're looking at is over the course of last 10 years, what you're proposing is 50% devoted. I think what we just heard from Adrian, and Adrian, please correct me if I did not hear it correctly, is that most of the certification requirements only ask for 25% of the practice to be specialized in the area. Meaning, I think the other certifications will say, if you are a general litigator and 25% of your practice is dedicated to labor and employment, maritime law, et cetera, benefits, et cetera, that would be considered a specialist in that area.
That feels low to me, but I understand if that's across the board with other specializations, then I think that's it's fair for us to harmonize.
Well, and that's why I was raising the question, is I actually like that you want it to be more stringent, but you know, from my days on CBLS, you know, the requirements, and again, I just looked them up again, was the passage of the written exam in the specialty area, and then practice law continuously for at least 5 years, spending at least 25% of the time given to the occupational endeavors practicing in the specialty area. So I didn't know if we could deviate from that and create a more stringent criteria, or if we had to go by what was on the general.
I would highly suggest sticking to the general of that same all across the board with that 5 years. And then you can go ahead and break them down on your tasks and experiences based on litigation, disputes, and all those other areas.
But what you're saying is that you would recommend that we stay in terms of the specialist area to the 25% requirement. Is that what you're recommending?
Yes. All the other specialty areas are that. So it'd be great just to stay mainstream with that first requirement, and then breaking it down possibly in a point system if that's what you guys choose to do for the task and experience. Like we had in previous meetings, we spoke about the state planning and such.
Mhm.
Those were the areas that we felt were closest to what you guys were trying to convey for your specialty area.
Mhm. So Mariah, I'm just going to propose for the group to consider. So, you know, having heard that, right? What if we slightly kind of combine some of your ideas here to the extent that we believe that privacy litigation is maybe more of a recent phenomenon, right? Is that the litigators are probably doing more privacy litigation in the most recent years. And also that will show that this is somebody who is actively practicing in this area in the last 5 years, let's say. What if we said something like in the last 5 years of proceeding the application, devoted at least 25% of your work to privacy, to the specialist area, and that would get us some points. So that's not going to say if you did only that 25% of litigation work was dedicated to privacy in the last 5 years, that would give you some points, but it's not going to be all, right? You would have need to do something else. Like, for example, take CLEs or teach or, you know, do some advisory work, et cetera. So I think there's some room to kind of think about, you know, if we think that 25% of litigation that's dedicated to privacy is not high enough of a bar, I think we can think about adjusting some of the parameters.
I would agree with that. My only response really is what of the applicants who are exclusively litigation? It sounds like you're saying they would get only some points, but not all this way.
Right. And that's exactly, I think, what we have to discuss, right? Is that
okay.
do we think the person who only litigates, right, and does general commercial disputes all year long, spends 25% of the time in this specialized area, do we add another numbers, you know, in terms of number of hours? So, you know, if you did spend 10,000 hours in the last 5 years, you know, even if the short, you know, time is short, is that good enough? Or are we going to ask for something more to be a specialist in this area? I think that is something to keep in mind.
Certainly open to continued discussion.
Okay. Unless there are any clarification questions or comments to the litigation experience, let's move on to the other areas, because I think this will become clearer, you know, after we have seen all of the 4 proposals. Should we move on to the item 5, item 6 and 7, rather? So next part, we're going to have Hillary and Lindsay lead the discussion, and you're going to be highlighting for us the research on the tasks and the experience portion on the advisory and regulatory compliance. Hillary and Lindsay?
Hillary, you want to start, or do you want me to? We didn't plan it.
So, yeah, I'll start with kind of the general, and I think maybe you can go through the what we talked about. examples. So we had the same, discussion about, do we focus exclusively on advisory and regulatory experience, or are these individuals going to come with experience in regulatory as well as transactional and some litigation? And so we looked at some of the requirements of the other specializations. So we again focused on the 5-year requirement. So in the past 5 years, the applicant has substantially participated in the performance of tasks in at least 5 of the following 10 categories. If they're in, and that is if they're solely coming into the specialization with solely acting as a regulatory compliance attorney, or 2 of the following 10 categories if they are coming into this with regulatory experience, as well as maybe they are a transactional attorney or they do some litigation. So again, the question of being, if they are coming in with just relying on privacy experience as a regulatory attorney, we'd want them to have substantially more experience in the next 10 categories that we lay out. If they are relying on regulatory as well as litigation or another facet of practice, then we would require fewer requirements below.
Right, and then just to go through the list of 10 here, one thing that I'll say before I go through these is that we weren't sure if these would be showing up in some of the other buckets. So obviously, to the extent that is the case, we can reconcile. So these are the things that we thought about. The first one is kind of general, drafting privacy regulatory compliance opinions, memoranda, or advice letters. And then the second one is also a little bit general, but it's counseling on governance and accountability with respect to a privacy program. And there's some examples of what that could include, like the development and provision of advice on policies, procedures, and processes relating to physical, technical, and administrative privacy controls. Then we had advising on conducting a data inventory or record of processing activities. So kind of the data mapping fundamentals. These next 2 might show up in the transactional list. I'm not sure. Drafting and evaluating externally facing privacy notices, and then the next one, internally facing privacy policies. The 5th one is advising on privacy elements of marketing, product, or service delivery, implementing privacy by design, and conducting privacy impact assessments. And then on this next slide, the last 4, we've got drafting and evaluating consent forms and advising on consent management, then counseling on data subject rights matters such as deletion or access, evaluating vendor data management activities and advising on privacy related risks. Again, that might show up in the transactional bucket. And then this last one, evaluating data sharing requests or counseling on cross-border data transfers and advising on privacy related risks. Again, that could show up in the transactional. And then we had some additional items as well that could be added, again, kind of thinking about reconciling across these different areas. This first bullet point is around privacy breaches, data breaches, and then incident response sort of related to that. And then this last one, negotiating contractual terms related to privacy protection. And that's it for us.
Thank you. Thank you, Lindsay and Hillary. Any comments or questions for the advisory and regulatory compliance tasks and experience? I have a question for you, just to start the discussion. So first of all, I would like to remind the public that members, the specific members that have contributed to individual sections, we have not had a chance to, as I think all of our speakers are alluding to, we did not work on them. We worked on them separately. So the litigation section members, research did not consult with the advisory regulatory compliance. And so I think we are seeing these for the first time. And we're discussing, how these 4 areas might overlap or talk to each other to the extent that we want to harmonize. So that's the work that we're going to be doing here during the public meeting today. So in terms of the advisory and regulatory compliance tasks, and I think you did the same kind of similar thing, you were acknowledging that you could have an attorney, a privacy attorney, that could be relying solely on their advisory and regulatory experience, and you are expecting them to have 5 out of 10 of these versus somebody who is doing some advisory work and maybe some litigation, as we talked about previously. Maybe you only did 2 of these things instead of 10. So that's clear. I think you were kind of thinking about 5 versus the 2 for those that are getting partial credit versus the full credit, let's say. The other members, we heard from Raya and Smita give a number of hours and kind of talked about, I guess you are focusing just on the last 5 years. Did you have a discussion on how these experiences could be shown? So for example, the fact that in the last 5 years, I drafted an opinion or I drafted a memoranda on privacy issues. Did you have a discussion on how to quantify that you have done 5 of these things or 10 of these things?
And we looked at other practice areas and we thought, well, do we say they have done at least 10 memoranda, or they've advised on at least, the development of 10 privacy notices? But that, we struggled with the fact that drafting 10 may not give you any more expertise than somebody who's drafted 2. So and we also struggle with an hour component as well. And so we landed on substantial performance. But of course, that is vague. And so we do welcome some comments on, is there a way that we can quantify this in a way that takes into account that what we're trying to get at is the experience and not necessarily, right, a standard minimum requirement of hours worked on a particular task.
Okay. So I think what I heard, I'm going to just say it back to you, is that we do welcome comments from the group on how to quantify this, and where we want to get to is substantial involvement in these tasks. So first, I think we would want comments from the group on, are these the right tasks that we think should fall under advisory and regulatory? That's the first question. And then second, to the extent that we agree that these are the right tasks that we would generally perform, that we would expect the privacy specialist to perform in the advisory and regulatory compliance areas, then how do we quantify it? Maybe we can come up with both. That would be my suggestion. Maybe we can say, X number of hours or X number of tasks, X number of memos, X number of policies. I think giving some guidance to quantify, and maybe a mix of those, because you're right, maybe it's 1 memo, but it took 2 years to complete. Maybe it's 10 memos, but they only took an hour to do it. And so I think there are definitely, and I think this really kind of showcases, I think, how broad the breadth of the privacy specialist work that I think the attorney community is currently engaged in. So I appreciate the members that are really thinking hard about how to quantify this specialist area. Any comments first on, maybe we can focus on the categories. Do we agree that these are the 10 categories that generally would describe an advisory and regulatory work in privacy law?
This is Arson, agreed. And I think there was a prior slide too, which covered a lot of the core components. So
That's right. So we have 2. So just a reminder, and maybe for the next presentation, just to remind everyone in terms of how, in terms of timing and the next steps, the next steps, the next meeting, we will be able to see all of these together. We're going to come back and we're going to discuss them in a harmonized fashion. So I'm going to just take a mental note here. It might be helpful to add numbers to these. And so we got 2 slides and 10 categories across slide 6 and 7. Let me maybe ask a more pointed question. Are there any tasks that we think could be added to show advisory or regulatory compliance work? Are these general enough to capture kind of the universe of work that we might be doing?
Can you return to the prior slide? I apologize, I didn't get a full.
And as people are reviewing the categories, I do note that there are a couple of tasks here that relate to incident response and breach. And so I think we will also be able to harmonize this across. Once we see the presentation from the last group, I think Michael is going to be presenting about incident response tasks. We'll be able to return, I think, and be able to make sure that there is no overlap between the two. So maybe go ahead.
I was just going to say, and I'm not sure if this is appropriate under the regulatory aspect or litigation, but some experience handling investigations with the California Attorney General's office and the newly formed California Privacy Protection Agency. I guess it's a little bit of a litigation skill set, but it could also delve into regulatory compliance. So it doesn't sit perfectly in one area, but that is also a relevant skill set.
Thank you for that. And you're right. I think it's responding to government investigations or providing to inquiries. And I agree. I think it could sit under litigation disputes, or it could sit under regulatory and advisory. And I don't believe we quite captured that under litigation. So we can kind of think about, where does it sit, in terms of government investigations. So because I'm thinking the litigation team was generally thinking about class action, right? Class action litigation, maybe arbitration, but was not capturing quite the government regulatory compliance and regulatory investigation side.
So I can speak to that. We did not understand our assignment to include kind of bucketing out the component parts, but certainly under the disputes category, we discussed regulatory investigations at both the federal.
Oh, I see.
Yeah.
Okay.
And then just based on experience, and I'm interested in everyone else's experience, I do think when you deal with regulatory investigations, you tend to get more of your white collar litigators involved. But of course, regulatory supports kind of the factual component to the responses. So that's why, I mean, we had discussed that.
Okay, that's helpful. I feel like maybe, just having seen these 2 presentations, and we'll continue to add complexity to it. The next section, we're going to be talking about transactional work. And, there are some categories under here on the advisory that also overlap with that too. So I feel like what we're getting to is that there might be maybe just the full list, we might not need to bucket it. We might not need to create, walls, right? Like this is litigation versus this is advisory. We might just come up with 10 things and you could get points for each of those 10 things. I feel like that could work. Because I think this really kind of speaks to, again, some of the work that a privacy specialist lawyer does is that you could be doing some advisory work and that could feel like it's regulatory work, or it could be also litigation. And I'm not sure that we have to create artificial walls to say you are a litigator versus you are an advisor. I'm seeing some head nodding. Please speak up if you do not agree, if you have a different perspective, but I think maybe we can just discuss that as a group, as we're starting to really kind of see, right, that these areas are overlapping. And so I think it's helpful. I think it was helpful to have our teams just focus on what is the full list of things for litigation, full list of things for advisory, and then now we will talk about how, each of these areas overlap with each other. Any other comments on, so again, let's see, is there anything missing? If we were to, again, come up with, this is a brainstorming session, if we were to come up with any advisory, regulatory compliance work, and what is not, what is missing from here? If not, we will move on to transactional. Okay. So thank you, Arsen. I think that was really great. And I'm really glad that Mariah, you were able to confirm that you did think about government investigations as being part of the litigation disputes experience. Great. We will move on to the next presentation with Arsen and Soyan, who are going to be leading the discussion, highlighting the research that you have done on the task and the experience portion on transactional work.
Thank you. I know Soyan wasn't able to attend today's meeting, but some of the issues we discussed are sort of in line with the conversation we're having of how broad or narrow should this list be. For example, with transactional, really the core, I guess, day-to-day job really involves the last bullet points here, where it's mostly about, M&A deals, doing due diligence, revising and drafting the reps and warranties in an agreement, buy side or sell side deal, or including the commercial contracts, the privacy terms, and outsourcing, which are mandated by data privacy laws and other best practices. However, Soyun also suggested that we think about broader skill sets that a general corporate attorney would need to know, because I think initially it wasn't just transactional, it was also just broadly corporate. And she made a good point that I guess depending on which the type of law office you work at, you might be the only corporate attorney, or you might be a corporate attorney in-house in a company, and you might need broader skill sets to be a good corporate attorney, and to understand privacy technology a little bit broadly and the intersection with the laws, also having some skill sets for data mapping, data minimization, doing privacy impact assessments, understanding when certain privacy laws apply, governance practices, and assigning responsibilities for different individuals within the company for different privacy tasks, incident response laws and issues, coordinating tasks with different privacy stakeholders as part of a coordinated effort, and collaboration skills. And so I guess it sort of goes back to the point you made, Jiwon, which is ultimately, I think it probably makes sense to have a laundry list of general tasks, because some of them might not fall neatly into a particular area. Like, for example, the bottom bullet points that I circled in green are the most direct when it comes to transactional, but the above skill sets, some of that is probably, a lot of it is probably bleeding over into regulatory compliance and advice, although with a slighter narrow angle here since it's just general corporate. But that was our perspective. As far as like experience level, etc., I think the position here is that it should be across the board experience, and different people, especially with privacy professionals, sometimes we wear different hats. One day we might be handling an investigation, other day we might be giving regulatory advice and drafting privacy policies, or we might be on a corporate team doing M&A deals on the privacy side. And so it's probably better not to compartmentalize the skill sets, but rather have some years of experience or hours of experience that picks different components of this to demonstrate your experience level.
Thank you, Arsen. Any comments or questions from the group? I'll kick up the discussion with some questions. Thank you, Arsen and Soyan, for your presentation on the transactional work, tasks, and experience. I think this is really kind of showing, again, kind of following the trend as I'm seeing with the third group. You seem to have created, because again, you are working in a silo, the two of you, not consulting with the rest of our group, that this is the full set of tasks that a transaction lawyer may be engaged in. And so I agree, Arsen. I think some of these seem to be bleeding over to the advisory side. Some of these, I think I know, are probably going to be bleeding into the incident response presentation, which Michael is going to do next. So I think it's helpful to kind of see that I think we are speaking the same language across all the different groups. And maybe it doesn't make sense to say that you could be just a transactional lawyer, because maybe a transactional lawyer could do some advisory work, could do some incident response work, and so maybe not create those walls. So I did hear that from your presentation. I'm going to ask maybe the hard question again. How do we quantify this? Have you had a conversation with Soyan? Because I don't see here in the presentation, the other members have talked about preceding 5 years, or is it 10 years? Is it life of your career? Have you talked a little bit during your research about capping the years, when you need to have that experience? Or did you have any conversations about number of hours or the number of tasks, the volume of the task? Did you have discussions about quantifying how to measure the knowledge, the skills, and the experience?
Yeah, this was not a conversation we had with Soyan. We just identified the actual tasks and skill sets. However, I do think a 10,000 hour and 5 year, if it's at 50% that Myra presented, makes a lot of sense. For benchmarking, I'll note that the IAPP's Fellow of Information Privacy requirement is 3 years of experience. And the way they demonstrate that is you have to fill out a form where you attest to having certain skill sets and the number of years you have experience in. And then you also provide 3 references that could essentially attest to your skill sets and that you've been doing this for a certain number of years. However, that is more for a privacy organization. So 3 years makes sense for IAPP. But I think the California State Bar specialization is an official recognition from a state bar, which in my opinion, I think might impose a higher bar from what I've seen with the other specializations. So having a 10-year 100% and 5-year 50% experience that Myra mentioned makes a lot of sense. I just think that we should think about it obviously with across the board, because somebody might have a mix of litigation experience in that area or transactional experience and a mix of both throughout their career and regulatory and incident response. So I think we should give flexibility on how to demonstrate those years of experience or hours.
Okay. That sounds great. So I think what I heard from you is that you're open to discussing how to quantify the knowledge, skills, and experience that you wanted to present for the transactional work, that you generally are in agreement with the way that the litigation group was presenting, which is a mix of kind of the years and the number of hours. I do want to, have the group think also, though, in terms of the number of hours and number of years, that we are really speaking for all California licensed attorneys. So, I'm thinking about folks that might not be in law firms. They might not be measuring, let's say, their time in terms of number of hours. So we might be, we might have a specialist that's in government, that's in-house, or as let's say in a nonprofit advocacy organization. So I do want to make sure that we are mindful that we're not just thinking about, let's say, a law firm experience, because I think the number of hours is, perhaps a little bit more maybe understandable from a law firm experience. Okay. I have a follow-up question. So I heard from you, Arsen, and from Soyan that you are thinking about there is a certain set of knowledge and skills, and then there is kind of a separate set of experiences. Do you think, when you are setting forward the knowledge and the skills that would demonstrate that this person is a privacy law specialist, are you thinking also that we could maybe convert some of these skills to experiences, or are you really kind of thinking about you have the skills, you haven't done it, but you have the skills to do so. So, right. So for example, the skills to determine data governance and compliance necessary. I'm just picking that as an example. Did you choose the word skills intentionally to say that you might not have any experience doing data governance work, but you have the skills to do it? Is that intentional? And then a follow-up question is, if that's true, that you're intentionally saying you don't have any experience, but you have the skills to do it, how would you show that? How would you demonstrate that you have the skills to do it, when you have not had the experience of doing so?
Yeah, I would say simply having skills without having it refined through experience was not the intent of the word
Okay.
skill here. So the skill sets need to be demonstrated or accounted for based on real life experience.
Got it.
Yeah.
Got
So
it.
for
So you
example,
really mean experience. So really, if I were to reword it to say experience drafting data governance and policy documents for an organization, that would accurately describe it?
That's correct.
Perfect. Thank you. Thanks for clarifying that for me. How about, I see here, which is interesting and I think a helpful contribution here, knowledge of staying current with technology and legal environment. Staying current, that is exactly what a lot of our privacy lawyers do. How would you demonstrate that you have experience staying current with developing technology and legal environment?
So I think if you're to view this as one of many list of things that sort of like a la carte, you pick and choose to demonstrate your overall experience. One way to show that you're staying current is through education. The other way would be through publications and presentations. So if there's a category where you devote certain part of your day or your years of experience to teaching privacy, writing about privacy, getting certified in privacy, for example, through IEPP and other certification courses. I think that's one way where there's like a concrete way to demonstrate that skill set. But then, of course, the other way, which is not really demonstratable, which is things you do on your spare time by reading articles and news alerts and things of that sort.
Yeah, because we are presenting a method by which the state bar can measure and assess, right, the applications. And so I think this is a very good conversation to have, and I think we can come back to it after all of the four groups have presented. Because what I'm hearing from you is that these are the kinds of the knowledge and the skills and the experience that we will want the applicants to demonstrate. And we would, I think we're looking for the group feedback on how to quantify it, and also to come up with the particular, list, right? List of tasks. So to show that you are staying current with developing technology and legal environment, which a privacy specialist should do, you must have, done X number of CLEs, or you must have written X number of papers, right? So I think maybe that's the next step, is to kind of synthesize. This is the type of tasks and experience that would demonstrate these knowledge, skills, and experience. Is that a fair way to describe it, Arsen?
Yeah, agreed. And I think another way, which I guess not to look too far ahead in the presentation today, but demonstrating it through MCLE requirements. I guess that's more forward-looking post-certification, but it could be thought of in the pre-sense as well, by demonstrating a log of, seminars you've attended or a percentage of your regular California State Bar MCLE existing requirements reflect taking courses in privacy or CLEs in privacy.
Adrian, you have a hand up?
Yeah, if I remember correctly, the next agenda item is supposed to be discussing the potential CLE subjects. So that is a requirement of all applicants. So they have to take within the 3 years immediately submitting their application. They have to have completed of CLE in whatever topics you guys decide. And then applicants can also, up to half of the requirement, can be writing scholarly articles or publications.
That's the discussion that's gonna be led by Paul, right?
Yeah.
Item B. Okay.
Yeah. Is that what you're referring to, like Arson?
Yes.
Got it.
So
Okay. Yeah.
can
So
we-
it's built
could-
into the certification program already.
It's
Separate
built
from
in,
tasking.
so it's a separate process, meaning the task and experience should not talk about CLEs because
Nope.
that's under the CLE. Is that right?
They're
Okay.
separate.
So really, I think coming back to this group in our discussion, we're gonna have a group presentation on the CLE requirements. And then, I think we talked about, there's an initial application and approval process. So what is the number of CLEs that you should have done just to be certified? And then there is a continuing legal education requirement that's going to apply to the recertification process. And for both of those, the initial approval and also the recertification process will have both the task experience and the CLEs that are kept separate, right? So there's a CLE requirement, there's a task requirement. Is that right? And let me just say it back, and because I was catching it while I was saying it, in the recertification process, I don't think we're going to have the task and experience, right? The recertification would be purely limited to the continuing legal education, right? You don't have to continue to certify. You're shaking your head. So you don't have to certify that you have continued to do this many policy governance, or you do.
Yeah. And again,
Okay.
so the requirements can be the same for both initial certification and recertification, or they can be different. So there's, like I was saying, like
see.
appellate, there's a couple areas where you have to do a little bit more experience to get your initial certification, but when you recertify, it's not as extensive, but you still have to submit proof of task
Continue
experience.
to work in this area. So, okay, so I was right. Because I think I was thinking about just regular CLE, right? So, for a California licensed attorney, for us to continue, with the bar, renewal, you don't have to show experience in a certain area, but because this is a specialist area, and that's what the group, I think, is going to be deciding, right? There is an initial approval. Here is a set of tasks and experiences plus CLE requirements for the approval to be a specialist. And then to recertify, there is going to be another set of task and experience and CLE requirements for the renewal, the recertification. Did I get that right?
Correct.
Okay, thank you for clarifying that for me. So I think we want to think about that, as we continue to discuss, is what do we require for the initial application and approval versus what do we require for the continue to be certified in the specialist area. So I think where our work is really going to be focused on the quantifying. How do we quantify this for the initial and also for the recertification? Any other questions or comments on the transactional work? If not, we'll go to the next section, which is incident response. Okay, I don't see any hands up. We'll go to Michael to present, to lead the discussion and to highlight your research on the task and the experience portion of incident response, data breach, and security.
Hi, good morning all. I guess the best way to phrase this, and again, I should emphasize that we've been looking at extreme compartmentalization of these 4 categories. We were not really working with each other. So I will be advocating and may be dovetailing to my advocacy of taking a more holistic approach, especially since I'm looking at more of a broader incident responses, breach, and security task and experience section. I actually broke it down to 5 main categories. Technically, the 5th one is an other category of just the different type of experience that you can do to satisfy probably this requirement if you want to make this a significant or a point system or whatever in between we want. So first I look at the legal practice itself, how experience as an attorney at a law firm or other corporate law firm settings, whether being corporations, nonprofits, government, and looking at just the normal drafting of just data privacy agreements to the different international laws, conducting researches, which is more like transactional, representing clients, and then I can break it down. You can go to the next page, please. So who's in charge of that part? Yeah, thank you. And just developing and implementing data privacy and cybersecurity policies, procedures, etc. More of a hands-on approach as an attorney. In addition to that, I also say consider prior work experience in legal IT. What I mean by that is more like at a law firm or in a courthouse setting, dealing with technology implementation and privacy matters may not necessarily be hands-on data privacy, mind you, but it's always will be an impact in terms of the different types of IT settings or anything like that, like legal holds, e-discovery, data retention. And I also say consider roles and experience from law schools, paralegals, and non-attorney roles as well. For example, at my current law firm, we're getting a paralegal who has extensive experience of years upon years of a particular area of law. And it will be behooving of us not to consider that in any application of hiring that paralegal if and when, I should say, they pass the bar exam. It's something really key and important to consider for just outside of experience, outside of box thinking, pretty much. Can you please go on to the next page? That said, the second category I was looking at is more about IT and technology in legal settings. It's interesting because for cybersecurity, data breaches, and incident reports, IT and technology roles play a key and critical part in working with attorneys on this particular subject matter. And in fact, some cybersecurity examinations like the CompTIA Security Plus tests on your skills and knowledge and abilities to coordinate with law. And actually, I believe, if I recall correctly, actually test some of the basic laws on that matter. For example, we're looking at technology roles as system admins, security analysis, software development, software engineers, privacy engineers, data and security and privacy. They're not limited to those, but it's an all-encompassing, including programming experience and implementing data privacy compliance programs or other stuff. It also is more about configuring security technologies, conducting risk assessments, and responding to security incidents as the IT and or programmer or other stuff. And then not only that, being able to understand and conduct assessments and penetrating testing, monitoring security logs and alerts, which is the data or evidence for data privacy, developing and maintaining security incident response plans because they're the ones who are the front of implementing, and participating in incident response exercises. Oftentimes, they're the ones who are more or less more tech savvy to lead in particular responses. Again, the consideration should be attorneys, law schools, paralegals, and non-attorney roles. If you go on to the next page, please. We're looking at consulting in legal settings, so this is more broader. It's not only legal and IT in the previous two sections. I'm now looking at more broadly of people with outside experience, not necessarily legal or IT in itself, such as consulting or advising. This section may be considered, but I don't, if we need to push back on something, this could be easily collapsed. But I was looking at, the experience and information and wisdom of being a consultant or advisor in guiding data privacy and cybersecurity compliance at other organizations. Again, not necessarily in a legal capacity or IT, software, or other capacities. And more or less, I broke it down to developing and implementing data privacy stuff, participating in government structures and committees. Think of it more like NGOs and other stuff, non-government organizations, nonprofits, other advisory groups. Technically, it could be considered as CompTIA and other cybersecurity related tests and organization and committees. Coming back, it's more about other stuff. So to move on, you can move on to the next page. Thank you. And I'm looking at academia and education and public presentations. So this is more of a broader scope of not only we have lawyers, IT software engineers, and what's called consultants. We're looking at academia and education, and so more of a broader sense of, well, are you active in this field? Are you proceeding on these subject matters? Are you specialized in actually teaching in these subject matters? Mind you, this is a legal certificate, so ideally it would be for people who are licensed as an attorneys, I believe specifically in the state of California, to be able to pursue this. And so, this certification. So this is just additional experience that's not necessarily pure on law, firm, or legal. And I break it down into what that entails in this subject category, such as cybersecurity, technology standards for attorneys and non-attorneys, publishing articles, podcasts, blog posts. I know people who do podcasts and blogs. That should be considered. How will that be determinative? I don't know. But for example, I put down, and I don't endorse it. No, sorry, the state bar of California endorses it, but there's relevant podcasts out there like This Week in Tech, This Week in Security, for a time This Week in Law for legal tech. Those are very educational, and it goes on current stuff. Should those individuals, if they're licensed to practice law, should that experience be considered? And of course, developing educational materials, programs, policies, etc. And then the last catch-all category, which is the fifth one, I was looking into more of programming and publicly launching apps and programs and other software or websites. Specifically, it's stemming from my own experience of being, having numerous of legal apps and programs on the Google Play Store and having to fully comply with all the data privacy of international stuff, not only on the programming level, but also on the storefront, all the disclosure statements, all the public disclosure stuff for European laws and American laws and California laws, tax structure systems, if you are gaining any financial incentives from your programs, and being able to fully be in compliance. That's probably is the notification of Google and Apple saying, oh, you're not in compliance for XYZ. You need to break it down into legal terms or procedures and being able to fully comply. That's just not, it'd be foolish to think you can just launch a program without having to be in compliance with any store policies, data privacy, and being impacted globally with different laws and rules, and having hands-on experience with these stores. That's relevant because I'm sure some of the clientele are exactly as such, as in having programs out there, and that's one of the main financial structures, such as Uber, Lyft, and other companies like that. Well, they don't necessarily have a website present. And then, this is the final catch-all is like other relevant professional experience. Too many to name, more or less. And then I think I have another slide. Yeah, thank you for that. I wasn't sure if that's part of the main slides deck at all, but other additional qualifications or certificates to consider, which is the CompTIA courses and other stuff, such as the Certified Information Privacy Professional. Interesting enough, I was told not to pursue a CIPP at all unless if my employer pays for it, because from all my own personal legal experience, I was told it would be irrelevant and they don't want to pay or have me spend time pursuing it and maintaining it. And it's a little interesting how I was actually just encouraged at numerous law firms on that. And then not necessarily because of the law firm practice, they just don't care about cybersecurity or data privacy. Going on, we also consider education consideration, which I think we will be discussing later on, which is about law degrees, specialization, such as if there's a class or academic course, or MCLE, which I can add on to that. Any undergraduate or graduate degree experiences, such as, we have some people who have computer science backgrounds, that should be relevant. Information security backgrounds should be considered, I believe. And then lastly, professional engagement. More or less, the different organizations out there, such as this committee for the State Bar of California, the Committee of Bar Examiners, which I was previously on. Having my specialties in this area helps build upon the committees and work, and especially advocating and developing future endeavors, especially when technology becomes more important. Similarly, with the American Bar Association, California Lawyers Association, and other organizational groups and regional groups, membership in these focus or areas may not necessarily prove practice. That said, it's more of if they would take on an active role or participant, or more of leadership, and or more of here's actual publications, which I am glad to hear previously that we will be considering that. So sorry for this in-depth discussion. I think I include some of my talking points, but also, like I say, this is taking all the previous 3 categories in isolation or compartmentalize, and hopefully with this 4th requirement, we can see more of a bigger picture now and see, and I think we have discussions on, well, we should not be considering only 1 or 2 areas, but we should be taking, and I think it's a fair assessment to say, more of a holistic approach to it all. How we assess that should be what I believe should be discussed. But thank you so much for your time. Any questions?
Thank you, Michael. Do we have any comments or questions for Michael?
I have a question. Michael, thank you for that. That was incredibly thorough and very enlightening. And I think you did a great job of, demonstrating how non-legal experience, could potentially be relevant. I guess my question is more to the staff as to whether there's any precedent in other specializations for considering non-legal experience. Does that make sense? Are we allowed to consider, for example, IT, work as an IT specialist?
So let's say, for example, because I had similar questions as well, Mariah. So let's say I recently graduated from law school and I have 0 legal experience. I'm going to give a kind of a black and white example, right? So I just got my license. I have not worked a day as an attorney, but I have 20 years, let's say, as an IT specialist. And I fit in one of these categories, let's say, that Michael has presented. Would we be able to say that because I worked as an IT specialist, but I have not worked as a privacy lawyer, I could still be specialized. I could still get the specialist designation as a privacy law specialist?
No, so there's just overall across all of the areas, there's a general 5-year practice requirement. So applicants have to have been practicing law for 5 years, and 25% of that time dedicated to practice in the specialty area.
And I guess my follow-up question to that, and excellent points, both Mariah and Joan, will be, what about the pursuit of extracurriculars? The pursuit of not necessarily a job, but you do this in your spare time, such as building up these legal programs and apps. Not to self-advocate for myself, but that's something that should be very considered, because in all, I can easily have spent more than 5 or 10,000 hours on weeknights, not days, but weeknights and weekends building these type of stuff and complying, and also the pursuit of additional certifications that may not necessarily be legal, such as CIPP. When I mean not necessarily legal, it's not a legal license in my opinion.
Yeah, I agree, Michael, and I think we're really seeing a trend. And now that we have had the benefit of the four different groups' presentations, and then again, because we did not work with each other, but we worked in these individual, teams. What we are seeing is that, Michael, your presentation, just like the other presentations too, we are seeing overlaps, right? You have some tasks and experiences in your incident response presentation that we saw, in the advisory presentation, in the regulatory presentation, the transactional presentation. So I think, Adrian, what you just said clarifies things for me. So let me just say it back to the group and see if this is the right way to think about it. When you say 5 years and 25% of that 5 years dedicated to the specialized area, does that mean 5 years immediately preceding the time when you apply? So let's say, this person is applying in 2024. We're looking at, for the last 5 years, did you dedicate 25% to the law practice of privacy? Is that right?
Correct. That's why during that first group, I had that question, if they're saying that you have to dedicate 100% of your practice to the area. Technically, for certification, you only have to dedicate 25%.
Got it. So really, it sounds like our task here, now that we've had, the presentation from everyone, from the four groups, is to really think about what is the list, the holistic, I think it's the word that Michael was using. So if I'm raising a question, if the group agrees that instead of having, one list of tasks for litigation, another for transaction, another for advisory, another for incident response, if we combine them all and put together a holistic list and said, these are the tasks and experiences that show and demonstrate, and we can quantify to be able to assess that this particular attorney with at least 5 years of legal experience has dedicated 25% of their practice to the specialized area. Would that be a good way to think about it? I guess this is a discussion for the group. Do we want to, I guess my first question and a suggestion is, could we come up with a full list? Do we want to keep, maybe it makes sense to have some key topics and acknowledging that some things could belong in one or the other, but do we want to maintain these 4 subgroups and come up with tasks and experiences under those? Or should we try to come up with one list that is drawing from these 4 areas that would make up how to assess the 25% specialized experience? Arsen, you have a hand up.
I think we should just have a general list of skill sets that are not necessarily organized by, subcategories of transactional incident response or litigation or otherwise. I think, some people will not fit neatly into some of these groups, and I suspect there might be some folks that maybe operate a solo practice at a law firm where they do bits and pieces of everything, or they're in government and they only handle investigations. So there could be a mixed bag. So I think people should have an a la carte choice of selecting what skill sets they meet during that, whatever criteria we decide on, 5 years experience or 10 years experience, etc.
I apologize. I need to leave the call early. I had let Janelle know, but thank you everyone for your time. And if there's any further assignments, please reach out and let me know.
Thank you. Michael, you had a hand up?
Yes, thank you. I believe the best way I can present this is I like the general aspect idea of here's some stuff to consider. It's one of those, do we want to make it so rigidly narrow, which is good for some particular reasons of making sure we meet the qualifications and all. Or do we want to also provide it broadly to provide alternative pathways to obtain this certification? And by that, I mean attorneys who pursue a different career path or choice, whatever. And it's stuff in which, well, for example, what if we have a public interest attorney who dedicates the time on public interest matters, but handles these matters every so often, but is also, say, for example, and this is not me, but I know someone else, who's on the committee of access to justice, other criteria, and ducktailing to that, it's interesting, but I was without I think I did not submit any applications for, but I got appointed by, I believe, the EBA government to be on the information in the technology and infosec department for EBA. That experience being relevant, in my opinion. It's hard. The reason I'm bringing those up is how can we quantify those relevant experience for certification if we look at it broadly and want to provide alternative pathways to obtain this license. And I should preface, sorry, last point. I was on the committee of bar examiners with Amy Nunes, and that's something we consider in terms of alternatives. That's something that I always advocate for and push for, because I believe if you meet or can rise up to the standards and requirements, you should have a fair assessment to get that.
Okay, thank you, Michael. Lindsay?
Thank you. I generally support the list of sort of the general, list of 10 or however many it ends up to be, in terms of tasks and experiences. I will note that, I think that we're all sort of alluding to the difficulty in quantifying these tasks. And I think that looking at what is the proof of experience could be different for the different tasks. So maybe we could go through an exercise of agreeing on the tasks and then looking at what could be sufficient to show, the substantial experience for that particular task or bucket. And I like the idea of a point system in general. I think that it's sort of this, menu of choices that people can, try to fit themselves in and allows for a lot of flexibility. I want to acknowledge, the points that have been made about previous experience as a non-lawyer. I do have concerns with the ethical aspect of that in terms of whether that encourages the unauthorized practice of law. I think that we need to be really clear on it, and it sounds like from what Adrian is saying that the other specialties really have a 5-year starting from bar passage rate, or you have to be a member of the California bar for 5 years practicing before this can kick in, or maybe it's another state bar. That's what I'm hearing. I got a thumbs up. So but I think that I want to acknowledge that in the area of privacy, it's really common to see people come into law school I teach law school. I see a lot of people come in with a lot of great experience that is extremely relevant. So I hear that. I hear that, and it's in so many different areas. But I want to just be cognizant of the ethical, guidelines there.
Yeah, I agree with you. I did see a hand from Rob and Amy, but now they're down. Did you have comment?
Yeah, I do have a question. Again, it goes back to kind of my first early on our question to staff is, how much do the individual certification, the individual specialty areas have their own criteria for that 25%? And how much, how much leeway do we have in creating kind of new standards against it? And then also, how much of it is what we're discussing here should be covered on the examination rather than on the requirement of, having experience. So again, back to staff, in terms of differentiating us from other specialties, how would that look and what kind of latitude do we have?
So Adrian, I don't know if you want to jump in here, but I think it varies from one specialization to another. There isn't a formula. And I think this goes hand in hand with the comment that I wanted to make, which is, I think the consideration here is, as with any exam, is what are the knowledge, skills, and abilities that need to be demonstrated, and in this case, to be deemed as an expert in this arena. So what I propose here is the thought that when you look at some of the qualifications that have been proposed, I think it has to factor in as to what is it, because the differentiation here in terms of the education and requirements, education experience and requirements for this specialization is it's not minimum competence, it's like excellence in this field. And so what you need to consider is knowledge, skills, abilities, and experience like that needs to come to that you need to bring to the table. And so when you're evaluating this, as each of these other specializations have done, is it's going to be proportionate to this arena. So for example, the example that Michael brought up as being a member of a committee at the state bar or with another like the ABA, that could be part of this experience. But I think fundamentally what the group has to address is this, will this part of the criteria address the knowledge, skills, and abilities required to prove excellence in this field? I think it's having that global perspective. So while I think it's important to know how other specializations deem this, I think it's very important for the group to understand that how all of these fit together. Like what is required of a specialist to prove that they are an expert in this field compared to like somebody who's doing this without being specialized as a generalist. So so maybe sometimes this could be weighting some of this, like other considerations are just a small portion of the experience that's required, the on-hand experience, or and so I know that I'm probably repeating things that Jiwon has raised multiple times here, which is that this is the opportunity for to factor all of these things in. But the distinction and the thing I want to highlight here is that what we're trying to do is come up with criteria that proves a higher standard than just a generalist here. So I just want everybody to keep that in mind.
Thank you, Amy. Michael?
Just for a quick clarification, these are the standards, in my opinion, to create the flow of the bare minimum in order to be assessed. Is that correct? I mean, there is an examination as well to get certified.
So I think the question is, because Amy, I think that the presentation you did was very helpful, because the certification process that we are establishing is for privacy law specialists, which I believe is different than, let's say, privacy specialists in non-legal settings. So I think we talked at length, as this group has been working through, all of the discussions we've had in the past, that a privacy law specialist by the California State Bar means something different than, let's say, being a privacy specialist, for IT, for example, professions. So I think it is clear from what Adrian and Amy said that we're looking for privacy law specialist experiences in the preceding 5 years. And I think really what we're trying to get to is, what is the list of tasks and experiences that are outside of the exam, right? Michael, you were saying there will be an exam and you need to pass that. There will be a CLE requirement and you'll need to pass that. But what is the list of tasks and experiences that you need to have demonstrated to show that you are an expert in this area, not just minimally competent, to borrow Amy's word, but you are an excellent source of legal expertise for this specialized area. And so I think so far what I've heard is that I think I heard comments maybe from 2 of you, so I would like to hear from the others as well. If we were to come up with a list of, here are the 10, 15, 20, I think it would have to be below 20 to make it manageable. And the description of the task and the experiences I would propose have to be broad enough to allow for, to Michael's point, allow for the breadth of the work that a privacy law specialist does. So let's say that we are able to come to an agreement on what that broad list of tasks and experiences could be. Then we can come up with a point system. We can come up with a weighting system. So let's say, for example, serving on the Bar Association and doing 10 events that's focused on privacy. You're not practicing, you're not paid for that work because it's a voluntary position, but does the fact that you organize 10 privacy events for this Bar Association, does it give you some amount of point, right? And maybe it's not the critical part of it, but maybe some part of it. So I think that's the kind of discussion that we want to have is first come up with the list of tasks and experiences that we believe demonstrate. And then secondly, how do we quantify it, right? How much point do we give to a particular task? Should we weigh certain tasks to mean more than certain other tasks? Does everyone agree with kind of generally the agenda or what we're trying to achieve here? I see some heads nodding. Does anyone have a different idea? Because, speak up or forever hold your peace. Does anyone believe strongly that we should keep the 4 areas of practice? So, because I could see that it could be helpful, right? To say, here is a list of tasks and experiences that are dedicated to incident response experience versus transactional versus litigation. Do we think that is still helpful to kind of keep those organized in subcategories, or is everyone kind of on board with having one general list, and that general list will have the tasks and experiences that speak to those 4 areas, knowing that some of the tasks and experiences do not fit neatly into one or the other? Either or, any strong opinions?
I support one list.
One list, okay? So we have so far one list winning. Anybody have strong opinions for keeping? Going once, going twice, we're going to move on to the next discussion topic if there is no one that is strongly feeling like we should keep the 4 areas distinct from each other. Okay, I am making sure that I'm not missing any raised hands. All right. Okay, then I think we have agreement, unanimous agreement from this group that I'm very, very appreciative of everyone that has contributed to the 4 areas. I think it gave us an idea to take a look at kind of the comprehensive list. And as we saw, each of the teams were really struggling to keep the comments and the presentations in that one narrow area. And I think we heard from all 4 of you that there are going to be overlaps. So I think the next meeting, what we're going to be discussing is, here's the list of one list. Here's a list of tasks and experiences that are drawn from these presentations that are going to speak to litigation and disputes experience. They're going to speak to transactional experience, and it's going to speak to regulatory advice and advisory, and then fourth, the incident response, data security, and data breach experience. And then we will, I think, be able to, one, agree that this is the right list of tasks and experiences. And then two, I think this was Lindsay's point, how do you quantify it? You know, let's say the topic is have done policies and governance work. Let's say it is as broad as that. You have done some substantial work in providing advice relating to privacy policies and governance. How do you quantify that? I have a technical question to the staff. The way that the direction that the group discussion is going, it sounds like what we're going to get in response, if we came up with these tasks, is basically a narrative statement. Is that usual and acceptable, that we will, basically the California State Bar will be receiving essays. It'll be a summary statement. It'll have a number of paragraphs, right? I'm just thinking logistically, it'll be a form with, paragraphs that says, explain, provide a description of, how you have substantial experience in, let's say, policies drafting and governance. It's going to be a qualitative list of maybe a bullet point list of the policies they wrote, or, et cetera. But is that generally how these tasks and experiences are presented by the applicants? Is that acceptable? Do you have any other ideas on how to make it so that it is not we're privacy lawyers, we generally try to stay away from open text fields, but it sounds like the best way to get this kind of qualitative information is to allow for open text, for somebody to describe their experiences. Is that aligned with how the other specialist areas assess experiences?
All applications, they have some type checkbox or saying that they've done certain things. And then a couple areas also require that they do have to include like a practice description. If it helps, I kind of put something together really fast. Let me just see if I can share it, if that's okay. Just to give you an example, it doesn't have to be like this, but based on the conversation. So everyone see my screen?
Mm-hmm.
So within the 5 years, this would be for like a cert application. You've been substantially involved in privacy law, which includes, here's your 4 areas. So then my practice has been devoted to handling substantial and direct participation in the following. Check at least one item. So this one is the oh, sorry, I might have mixed things up. It's a really rough draft. This one would be like the litigator. I've been engaged as a litigator. And then here's a couple of those points that were from that slide. Or I've been engaged as an advisor. And then here are those things. So then if you check this section, you must check at least 5 out of the 10, which I think that was what that slide said. Or you've been engaged in transactional work. This one, we just want to know what type. There's no minimum requirement. We just want to know what type of transactional work you've been doing. If you're saying that you've been engaged in incident response, just check like how legal practice, IT, consulting. And then we also require, so here's your statement of purpose or your practice description, also provide that. And then all specialty areas, we do allow other experience. So if they're unable to make a prima facie showing of the requirements, describe your practice. Tell us why you are a subject matter expert. Tell us exactly what you're doing qualifies you as
if it doesn't fit nearly neatly in those above criteria.
Yeah, we do include this for all specialty areas.
Okay. That's super helpful. Thank you for showing that to us, Adrian, in a graphic way. What you're suggesting is, and so that's my clarification that I needed, is that we're not going to be looking at paragraphs, right? It could be as simple as checking a box that says I have substantial experience doing policies work, doing contractual transactional work. Okay. That is helpful. So really, going back to, because I think, you are drafting this in real time, which I, appreciate very much. I think it sounds like we're walking away from having 4 separate lists, but it will look visually similar, it'll say, here's a list of 15 things or 20 things that you could check. And, if you have this many checkbox, or if you can, qualify that maybe you have only one checkbox, but then you have this many hours dedicated to this one checkbox, right? So we would have to we have a number of things, I think, to think about is one, what is that list? That is going to be demonstrating the tasks and experiences. Two, do we weigh one thing or another? Or do we just allow some things to fall to the bottom of the form where you say other, right? So what kind of belongs on the top? This is the checklist of tasks and experience that belongs to demonstrating that you're an expert in this area versus maybe some other ones would fall to the other. That's the first. Second, do we want to have a point system to say that you meet a certain points? Or do we go by the number of things? So, 5 out of 10 or 3 out of 10, because I feel like we are really representing a very diverse group of privacy lawyers. And so I'm cognizant of the fact that maybe there could be one privacy specialist that meets 1 out of 10 of those tasks, but that is all they do. And let's say that they have 2,000 hours in the last year just doing one thing. Let's say it's litigation. Is that good enough, right? So I think we really kind of have to think about allowing for the breadth of the privacy law community to be able to present and to be accepted and approved as a privacy law specialist. So I think that'll be the next task is to agree on the full list of tasks and experiences. 2, think about point system. Do we award points? Do we not? And then number 3, do we weigh them? Do we not? Is one experience more meaningful than the other? And then what are some other experiences? To the extent that we have some experience that we would want to award, but maybe it doesn't belong in that top fold list, we'll let the applicants explain it in a more qualitative way. And I think really it's becoming a little bit more clear for me. It is really about the last 5 years. So it's the 5 years preceding the application and being able to show that 25% of that time was spent specialized in this area. And here is the list. 10 things, check this, and you have shown that you have spent at least 25% of your time in the last 5 years. Did I capture generally what we are learning through the presentations today? I'm seeing some heads nodding. Does anyone disagree? Does anyone have a different way of kind of thinking through what the agenda for the next meeting might be? What I'm suggesting is that next meeting, we will come back with one list, not 4 lists, but one list that's going to look similar to what Adrian just marked up brilliantly in real time. And it's going to have this list. And then we will discuss as a group next time whether we go with the point system, whether we weigh one thing or not. And so I would love for the group today to, if there are strong opinions now, speak up. Do we like the idea of assigning points? Are we overcomplicating things? I think the particular draft that Adrian showed, I did not see points, right? It really was a checklist of I have done these things. I'm also cognizant of trying to make this, not overly complicated. So does anyone feel very strongly on, yes point system or no point system? Or are we going to discuss it as a group once we see the draft next time? Any strong opinions on points?
I'll
Not a
just chime
strong
in that
opinion, but I'm sorry, go ahead, Lindsay.
I was just gonna say strong opinion for point system.
4.
4.
Okay. Rob?
Yeah, I don't have a strong opinion. I just think, being consistent with the way that the rest of the specialties, is something that is solid because we've established it at CBLS. So that's the only comment I have.
Right. So whatever we decide and approve and vote on during the next meeting, I think we'll be coming back to this group and saying, this is generally how, right? And here are some examples of the other groups in terms of the pointing system and the weight system. Lindsay, what are you thinking in terms of the point system? So let's say we have a list of, let's say 15 things. Here are the 15 things that we have agreed are the tasks and the experiences. Are you thinking that you give points to each of those things? Are you thinking, let's say I've done 10 policies and I've done 10 transactions, I've done 10 litigation things. You know, do I get point for each of those tasks? How are you thinking the point system might work?
To me, I feel like if we can come up with a list that each of the tasks can be weighted equally, that would be, I think, easiest for administrative. You know, so if it's a list of 10 and people get to, you know, 5 or 6 out of the list of 10, you know, I think we'll have to decide how many they need to check off the list.
Mhm.
You know, I think that would be the easiest. I mean, I think there's all different ways that we could do this, and it might help to just get to the list, and then we can, you know, talk about how things are weighted. One experience that I have is through, I administer a program at Santa Clara Law called the Tech Edge JD program. It has a similar sort of list of skills / experiences, and what we have come up with is a list of 11, and 2 of those we consider core. So it's not real, you know, so in that way, it's sort of like you know, there's more points, you know, so we could, you know, sort of either assign more points to certain things that we feel like are core, or we could just say these things are core, right? I think that given the breadth of different experiences that we've been talking about today, I don't know that we can identify anything as core. You know, so kind of a choose your own adventure, you know, system, I think, is helpful.
Yeah. I like the idea. I think I heard two different things from you. So let me see if I captured it correctly. So first of all, I think you like the idea of having one list, but then they are, you know, weighted equally. But secondly, you know, on top of that one list, you could have, you know, separate lists that are determined to be core. So maybe, you know, we can come up with, these are the must-haves, and here are the nice-to-haves, and you have this many out of the nice-to-have, plus you have these must-have, and now you have demonstrated that at least 25% of your time has been specialized. So I like that idea. I would just ask the group to think through, because I think there have been a lot of comments made about kind of the breadth of our practices and how a privacy law specialist could be doing many of these things, many different hats. I also want to make sure that we are also recognizing that there could be some very, very narrow specialists, you know, where, you know, we don't want to inadvertently, I think, exclude specialists that would have, in terms of the nice to have, right? So let's say I'm a litigator, all I do is litigate. I only do 1 out of these 15 things, right? But I do a lot. 25% of time is spent doing 1 out of these 10 things. I think that would still qualify to show that you are a privacy law specialist. So I don't want us to inadvertently, you know, only prefer and only allow for a practitioner that has a very broad practice in privacy. I think we want to think about a broad practice and also a narrow scope of practice, and make sure that experiences for both types of practitioners can be recognized. Does everyone like, do you agree with the way that I'm thinking about it in terms of kind of the breadth of the practice and perhaps some narrow scope practices that some of us may have? And then do you agree with that? And then 2, do we like the idea of kind of the core? So here are the tasks and experiences that every specialist must have. And we haven't agreed yet what is, right? We haven't agreed yet and what are the core tasks, but do you like the idea of having core versus here's a menu of options?
I like that idea of having core minimum requirements that everybody must have, and then you have, you know, we bucket them in such a way that you could have the narrow specialist also, you know, be able to meet the requirements as well as the generalist in privacy, right? Meet those requirements. Support that.
I
Make it good.
think having
Go
a list of core topics, I think that's a great idea because as we've discussed earlier, there are a wide range of different topics, right, that a privacy professional would need to know, and it could potentially mean that someone with a pure security background, may want to have this privacy specialist certification, and if they haven't had any experience related directly to privacy, and if their experience is solely in relation to security, then it could a bit hurt. I think the specialization. I'm not saying that we should not recognize security specialists. I think that it would be great to have them and so forth, but then they would still need, I think, to demonstrate experience with some of the core privacy fundamentals. So having this list of core principles, I think that would be key to ensure that we do maintain some experience in privacy.
The one thing I'll add is if we do have a core list of mandatory experience, I think there should be some level of flexibility of like 3 out of 5 or 5 out of 6, something to that, or 4 out of 6, something to that effect. The reason why I say that is because somebody could be a well-rounded data privacy attorney, but maybe they have 0 litigation experience because they were in the corporate department, or vice versa. Maybe they are in the litigation department at a firm, but don't have experience doing M&A deals or contractual work related to privacy. So I think we should acknowledge like core skill sets, but have flexibility on this many out of these core sets, skill sets you need to fulfill in order to have the minimum criteria.
I like that idea. I think the most difficult job that I think we're going to have is to agree on what we think are the core, right? To the extent that, because I think we're perhaps going into a circle a little bit because, let's say, I think we have good examples. Let's say the security person, who only does incident response work. And if we say 3 out of 5, so maybe, one core skill is doing incident response. What are the other 2? Right? And what are the other 2? Are we going to say that a incident response person, that has spent all of their time just doing data breach response? What are the other 2? I think, Paul, you described it as in core, privacy fundamentals. I think that's going to be the most difficult part, right? Is that, how do we give flexibility enough to allow for the person who might not be doing one thing all, the entire time, and has many hats, versus you do have some specialists that are doing just one thing, let's say litigator, let's say security, data breach attorneys. So I think that's what we're going to be looking at during the next meeting. We'll come up with, based on the presentations today, one big list. And then I think we will discuss as a group which of those are maybe pulled up to the top and say core and mandatory, versus here are the list of other tasks and experiences that give you some amount of points. And if you have this many points on the tasks and the experiences from this available list, then you have demonstrated that you have at least spent at least 25% of your time in the last 5 years. Any thoughts on, again, we're looking ahead at the next meeting's discussion. Any thoughts, any strong opinions, yay or nay, on what should belong in the quote unquote core or mandatory set of tasks and experiences?
I could give some core. For starters, I think one of the core skill sets should be regulatory advisory related to data privacy. The other one I'm thinking about is having experience handling privacy related litigation. The third would be privacy experience in either M&A deals or transactional. And then the fourth would be having privacy experience in handling incident response. And I think from, I guess, that list of broader categories, I think you should be able to meet at least 3 of those skill sets or 2. I think we could talk about that maybe next time, but you should first check off one of those several of those boxes, and then once you do, you can then maybe use a supplemental list to get additional points if we're doing a point system.
So thank you, Arsen. I'm taking notes here. So you suggested for core 4, possible for what we would call experiences, regulatory advisory, litigation, transactional, and incident response, which I think roughly link back to our original 4, subgroups that we talked about. I'm not sure that I agree with you that it would have to be 3 out of 4 of those things, right? Because if you say you have to meet 2 out of 4 or 3 out of 4, anything more than 1, I think that would exclude somebody that is, exclusively doing litigation or exclusively doing transactional, right? So you could have a corporate partner that spends 25% of the time, doing DPAs, and 25% of, his corporate practice is doing transactional work for privacy. And that's the only work that you do. You don't do any regulatory advisory, you don't do any litigation, you don't do any incident response. So are you saying that corporate partner that spends 25% of time doing data protection agreements would not meet the minimum category in terms of being a privacy law specialist?
I think if they only did transactions, which I don't think that usually happens. Usually, like if you're advising on privacy terms in a contract or during an M&A deal, you'll also provide advice about, hey, here's what the CCPA says, here's what you need to do for compliance. You review privacy policies, you might provide some regulatory counseling services. I think if you just hit one box and that's it, that's the only worldview you have. I don't know if you qualify as a privacy specialist. I think that's hard to justify because it's just such a narrow area that you would be in that it's hard to say you have a holistic experience. And I'll give an example. Let's say your only experience in privacy is you only do data breach work, incident response notifications. That doesn't require knowledge of CCPA, doesn't require knowledge of, data transfers, drafting privacy policies, handling litigation. And I'm not saying you need all of those skill sets, but I think you need to check off at least one more box in order to truly be a privacy specialist. Otherwise, you only have like one narrow experience area on a very micro topic. And maybe you're a specialist in, I don't know, litigation or data breach response, but to say you're a privacy specialist, like you have a holistic knowledge of privacy in general, I think you need to check off at least one more box as a core component.
Thank you for that, Arsen. I see hands up with Michael and Lindsay. Michael?
Hi, thank you for that. I also will like to stress more like the extreme circumstances of this. We may not be able to capture individuals such as myself if we only talking close stuff like that. I can almost show you at this moment, I won't be able to qualify for anything. And I think maybe good, maybe bad for me not to have a certification, but I just think you'll be missing some individuals such as myself if we do too narrow. Not to be self-interest or anything like that, just a consideration. And I'll be more than fine if I can't sit for the exam, but I have contributed, so I don't know. Just my thoughts on that. So you have at least explaining other circumstances or other evidence of specialties that you have done.
Thank you, Michael. Lindsay?
Yeah, I was just looking through the list of tasks from all 4 groups and trying to find some commonality. And I don't know that there is one. And I'm wondering if looking at, and I know that I mentioned the structure of having the core, in terms of the tasks, but I wonder if we think about that in terms of that in some part is could be fulfilled by the exam, right? I mean, I think the exam in part, or the exam alternative, whatever that ends up to be, shows a demonstrated knowledge of privacy. And I think that's part of what maybe our discussion here about trying to capture a specialization, a true specialization. We want demonstratable knowledge, right? And I think that is potentially through the exam, or the exam alternative. One thought I did have around a potential kind of core task, and I'm not sure how to quantify this, but is technology. I mean, I think that there is a sort of through line around all of the practice of privacy in that, there is staying current, and having a demonstrable knowledge of technology. And again, that might be as part of the exam, is important, I think, to being a privacy specialist. So just throwing that out to the group.
Thank you, Lindsay. Any other comments? Looking for raised hands. I would like to get some comments in response to what Arsen has suggested, because I think this is really kind of at the core of what this group is tasked to decide. You described it as being a holistic expert, Arsen. So, in the last 2 hours, we have discussed how we want to allow for a privacy specialist that has a very broad practice like mine, because I do litigation, I do government investigations, I do transactional, and I do incident response. So, in my personal experience, I check off all 4, right? But I'm also cognizant that my partner, only does incident response, or, my partner may do only litigation. And so I've been really, trying to allow for specialists that it does not have a broad practice that I have. What you're suggesting, Arsen, I think, is that even if you are a litigator, even if you are doing incident response, or you are the corporate partner that happens to do privacy work, 25% of the time, that there has to be some additional core competencies. Because, going back to Amy and Adrian's point, is that we're not looking for bare minimum, right? To be a privacy law specialist, we're looking for somebody who is an excellent expert in privacy law. So does everyone agree that let's stick, or for the sake of conversation, let's stick to those 4, because these are the 4 that we discussed, right? I think this is now 7 months ago. So, two meetings ago, we said that these are the 4 general areas that privacy specialists practice in: regulatory advisory, litigation, transactional, incident response. Does everyone agree that if you have experience in only 1 out of the 4, it's not good enough? That a privacy law specialist that is meant to be an expert in privacy law should have competencies or have demonstrated experiences in at least maybe 1 or 2 more? I think, Arsen, you were starting with 3 out of 4, but let's start with more than 1. Do we agree that it has to be more than just litigation or just transactional work?
I agree.
Jesus agrees.
Yes, I agree. I agree with you.
And I see Rob nodding your head. So you're also agreeing, not Rob?
Yeah, I think that it should be more than 1 area. At the end of the day, and again, Adrian, correct me if I'm wrong, what we're talking about is for the ability to sit for the exam, right? So they still have to pass a competency exam.
Right.
So we're saying that you have to have at least more than 1 area of experience in order to sit for the exam. That doesn't guarantee you're going to pass the exam if you don't have a wide range of experiences.
Yeah,
That's correct.
Just to clarify one of my points, and certainly, like, somebody, for example, like, let's say they're in litigation, right? They could still check off more than 1 box, because if you're a litigator, not only are you in court and defending a privacy case, but simultaneously you're advising your client, like, hey, there was this incident, we're in court, we're going to defend this lawsuit and draft a brief a certain way, etc. But you're also advising them on mitigation measures of, hey, this is why this lawsuit happened. Here's what law is at play. Here's a memo about your likelihood of prevailing or not prevailing and steps you can do to mitigate measures. And so that touches on the regulatory advisory side. So somebody could be simply in a litigation department and simply do litigation, but part of their job would also be advising on how to remediate a problem that happens. So technically speaking, somebody that, again, is a purely in litigation department could still check off 2 boxes. And I think we can clarify for each criteria, these are the various skill sets that would fall within it for you to qualify for checking off that box. Again, same thing, if you're in government, let's say, you could be in the DOJ or whatever the case might be. Not only are you investigating, let's say, privacy violations or security incidents, but computer crimes, but you may also be advising the government on, what does this law mean? Why is it relevant, etc. And so there could be an advisory side to that practice as well. So I don't think it'll be overly exclusive if we require checking off 2 boxes. I don't think checking off 2 boxes would suggest that you need to be both in the litigation department and the corporate department, or specifically sit in a practice group for regulatory advisory. It's not a matter of like what title you wear, but more of your experience. And that's sort of where I'm getting at.
I hear you. Let me suggest something, because we moved away because we talked about how it's difficult to have a certain list of tasks that fall neatly in one of those 4, right? So what if we could combine, what we were talking about until now, which is, let's say that we have 4, areas. So it's regulatory and litigation, transactional, and incident response. And we say you have 1 out of the 4, at least 1. Somebody might check off more than 1, but is saying that you have spent at least 25% of your time in the last 5 years in doing privacy-related work in 1 of 4 of these areas. And below that, we have the full list. And that's, I think, where we can maybe address what you were saying, Arsen, is that in addition to being a litigator that does privacy litigation, you must have done at least 5 of these 10 things. Right?
Oh, okay.
Is that in addition to being a privacy litigator, I have advised on Invasion of Privacy Act, or I have advised on policies, privacy notices, and deficiencies related to litigation. That's focused on online trackers. So maybe that's the way, because if we don't do that, I think we're back to 4 separate lists of tasks and experiences, right? So I think we could maybe combine them to say 1 of 4 plus these. That shows that you do have a holistic, that you are an expert, that you're not just doing litigation, but has advised on compliance, has kept up with the technology developments, as Lindsay was saying, or has worked on incident response, etc. Right? Because maybe you're not the person who is doing deals, but maybe you are brought in to advise on contractual terms. And so, I think having that task list, combined 1 task list, and making it so that you have to have more than 1, right? Might capture, I think, what you are trying to achieve.
Yeah, I think so. I think like maybe if, I don't know how to quantify this, but let's say you pick 1 from the 4 or 5, and that gives you 25% to get to, I guess, 100% of meeting the required points. Then the remaining 75% can be captured by other skill sets reflected in the broader list. Is that what you were thinking?
No, because I think what you are saying is you still have some tasks. So I'm trying to move away because I thought we had discussed it, but you're bringing us back, right? So it sounds like you want tasks that are under litigation. Because what you're saying is, I might be a litigator, but I might still be advising on regulatory compliance. And so you want to explain, what does that mean, right? What does it mean? And so I think you are taking us back to having a separate list of tasks and experiences under those 4.
No, that's
Okay.
no. I think there should be a long list of the various skill sets because they bleed into each other. That's the problem.
Right.
So there should be a long list. But I think if we're gonna have like, here are 4 core areas that you have to meet 1 of or 2 of. If we're gonna go back to like you have to pick 1, I think the 4 should be listed in a broad manner. Like you do litigation related to privacy, you do transactional related to privacy, you do regulatory advisory related to privacy,
Right.
or you do incident response related to privacy. You check 1 of them. Like you meet, that's the minimum you need. Let's say we go back to the 1 criteria. The other thing you should do is to supplement that, so you're holistically a privacy attorney, you would then have the full laundry list of things, and there should be some point system for accounting for the remaining balance of points you need in order to be competent to sit on the exam and gets qualified as a specialist. So, I mean, again, I'm not married to a particular point system, but let's just give one example. Like, let's say you get 25% automatically if you hit one of the 4, then you need to meet 75% of points from checking off, I don't know, it's a list of 20 or 30 tasks there are that bleed into different practice areas in order to qualify to meet the other 75%. That's sort of what I meant by that. So it's sticking to the checklist, but if we're talking about a core system, it would be like 4 or 5 core broad skill sets.
Adrian, you have a hand up.
Sorry. If I'm understanding the conversation right, sorry, can I share my screen again?
Mm-hmm.
And then there's a couple of ways you can do this too. So I just made up some points. So let's say you want an applicant to get 150 points. So each of these 4 categories alone will not make up 150. So they're going to have to claim points from another area. So the litigation disputes, I said under 20 points, it's just 40 across those 3 things that were listed already. Advisory regulatory is 100 points. It was just 10 points for each of those 10 things. Transactional work, the max was 140, just 10 points for each of those things. And then the incident response was 100 points, just 25 for 4 categories. So this means that unfortunately it singles out people who are like 100% litigation.
Right.
But it does require them to have experience in some of those other areas.
So,
and I think it also,
and
I think that's right, but it's not, these are not all equal, right? Because the way you have it, I think that's right, but I think this
it doesn't have to be equal. Sorry, I was just doing it for the sake of time.
What I'm saying is that having a list and having each of those things, up to 10 does not work, because let's say, all I do, and then maybe it doesn't, well, let me rephrase. It would not capture the person who is doing one particular type of practice. So let's say I am a corporate attorney and I do not advise on incident response. I don't get bring into litigation or government investigations, but I do advise on privacy issues related to agreements. And I spent a lot of time, right, in advising how to do agreements and how to do contractual relationships related to privacy. 25% of my transactional work is really looking at the privacy laws related to transactions, right? So you might not have, 3 out of those 10 things. You might just have 1 out of those 10 things, and you only get 10 points, right? So you might not get to 150 that is needed because you're only meeting 1 out of those 10. So I feel like we are overcomplicating it. So let me see if I can, bring it back. I think I'm hearing from everyone that there has to be some element of core, right? There's a concept that that we do not want, and please disagree with me, but I think what I'm hearing from the folks is that there has to be some set of core competencies, and we don't believe that an attorney that does just one thing should be allowed to have a certification as a privacy law expert. Okay, if we agree with that, the next question is, okay, then what is the core competency, right? What is the set of experiences that every privacy law expert that is licensed and certified by the California State Bar should have, right? So if that is our goal, is to allow for some specialists that only do one type of law, but then to force them to show us that it's not just one very, very narrow thing, but broad enough that they have general understanding of the laws, general understanding of the technology issues, generally able to navigate, at least to issue spot, even if you don't know how to litigate, at least to issue spot, right? And be able to refer matters to the litigator next door. Could we move away again from the 4, because I think the reason that we walked away from the 4 is because I think we really didn't find that, the tasking experiences fall neatly in those 4. I think what I would like to suggest, Adrian, you're really quick in advising this, is let's come up with 15. Let's come up with these 15 things that we believe show and demonstrate that you are an experienced expert privacy law. And out of those 15 things, we can say, right, and those 15 things will speak to the fact that you are a litigator, that you are transactional, that you provide regulatory advice, that you're a product counselor, et cetera, right? Out of those 15 things, we can say, is that doing 3 out of those 10 things? Or, if you did 1 out of those 10 things, does that, can you, mitigate the fact that you've only done 1 out of those 10 things because you've done 10,000 hours, right? So maybe come up with ways to simplify it, because I don't think I like, having to kind of check off multiple places, 25% here, 75% here. I think we should come up with, here are generally the tasks and experiences that a privacy law expert does. And if you do these things, these 3 things, or these 5 things, and you've done that for 25% of your time, then you have enough expertise to sit for the exam, right? And Lindsay's point, some of the core competencies will be tested, through the exam, and we're going to have the CLE requirements, right? So before you can be recertified, you have to continue to, stay on top of the laws, and you have to continue to work in this area. So I think we have a couple of different ways to check it, but that would be my suggestion. Make it simple, come up with the 10 to 15 list of tasks and experiences, decide which of those or how many of those need to be met to be able to have a minimum competency showing, minimal expertise showing, I would say. Anyone have likes, dislikes, different ideas? Thumbs up from Lindsay, thumbs up from Arson. Think about it, because I am cognizant of the time. It's now 12:30, and we have, I believe, 2 different sections left. And if we are to close within the scheduled time, which I believe is 2 p.m., we have to move forward. And so I think we're going to break, if that's okay with everyone. And the next remaining, and I think this will, continue to be a little bit more clearer, for the group to think through, is Paul is going to present next on the CLE requirements. So in addition to the tasks and experiences, we have the CLE requirements. And then Ryan and I are going to present on the alternative to examination. So just giving you heads up that that's what's coming. And alternative to examination, meaning this is for the folks who are going to be approved to be a specialist before the exam is approved. So this will be for the very first 2 years only, after the privacy specialist designation has been approved by the California State Bar. So this will be alternative to the exam, because the exam has not been developed yet. So that's yet another area, I think, that would allow for, the specialist, since we are creating the specialist designation for the first time. So if you want to take a break, I'm not sure that we want to do a 1-hour break. I think we could do a 30-minute break. Ryan says no. Everyone probably needs some time to go grab some food. It is lunchtime. Yeah. Can we live with 30 minutes? 15 minutes is too short, I'm assuming. Is that a thumbs up for 30?
30 at least, yeah.
30 is okay. Everyone could come back by 1 p.m. That'll give us 1 more hour if we're going to finish on time.
And Juwan, sorry, I'm gonna have to drop off and not rejoin. I have to teach at 1. But please sign me up for whatever you need.
Thank you, Lindsay. Appreciate it.
Thank you.
All right, thank you very much. This was a very lively discussion, and I think we all benefited from the group's expertise in these areas. So we're going to break for 30 minutes now. The recording will stop, and we will resume at 1 p.m. So now. Okay. Thanks very much. It is now 1 p.m. We'll go ahead and resume with the meeting of the Privacy Law Group, starting from business 3B. Just to recap, and I think we had a very lively discussion before we broke for a break. And we will be discussing first the presentation from Paul, as I mentioned, on the continuing legal education topics. And then Ryan and I will present on the alternative, and then we'll recap at the end, hopefully in the next hour, to keep with the scheduled time for today. And we'll recap on where we are, and we'll ask for some additional member feedback at that time. So for now, if we could turn our attention to Paul. Paul's going to be leading the discussion on and highlighting his research on the legal continuing education subjects and topics. Paul?
Hi, Ron. Sorry, I was pressing on the unmute button and it didn't work. Anyway, so in relation to the MCLE requirements, Jesus Martinez and I did the research on the MCLE and the legal specialization CLE requirements. The first component would be what are the number of hours, the number of CLE hours that individuals should be expected to do. And our proposal is to just align with what are the current requirements under the California State Bar for legal specialists in other areas. So our proposal is that we follow the same requirements. So the requirements as they currently stand for all legal specialists would be twofold. So you have going back to this slide, the general MCLE. So that is the standard requirement for everyone. You do have 25 hours of MCLE, which are required within a given 3-year reporting period. And the 25 hours of MCLE can be broken down into 2 parts. You have 18 hours of general MCLE, and then 7 hours of MCLE in specific subfield credits. So you have 4 hours of legal ethics, at least 1 hour of on competence issues, at least 2 hours in elimination of bias, with at least 1 hour in focus on implicit bias and promotion of bias reducing strategies. In relation to the legal specialists specifically, the requirements would be on top of the general MCLE in the sense that you would have to prove 36 hours of legal specialist CLE in the respective specialty area within the same reporting period. But then it doesn't mean that you have to do 36 plus 25. Instead, how it works is that you are able to count the 18 hours of general MCLE towards your specialist area. So this means that at a minimum, a legal specialist would need to complete 43 hours of CLE. So this means 36 hours in the area where you are specializing in, so it's privacy law, but then you would have the 7 hours of MCLE subfield courses, which would still need to be taken just like everyone else. So this information was taken from the State Bar of California reporting requirements in relation to legal specialists, and we think that the requirements should be the same for all specializations. If we move on to the next slide, now we're going to be talking about the different topics to be covered under the CLE, and our first stop was what is the IPP requiring in terms of CIPP certification? And we looked at those because, it is a common certification that lots of folks obtain, and therefore it can provide us some idea as to what is typically required from privacy specialists. So if we look at the CIPP US certification, here we have on the slide, we have the different topics that they would cover in order for you to get the CIPP certification. You would have the US privacy environment with the structure of US law enforcement, how information management is done from a US perspective. They would look at limits on private sector collection and use of data. They would be looking at specific industry requirements, for example, FTC privacy protection across different sectors, but also requirements in the healthcare, medical field, financial field, education field, and also in relation to telecommunications and marketing. The third topic that they would require would be government and call access to private sector information. So this would mean law enforcement, national security, civil litigation, and privacy. They also consider workplace privacy. What are the requirements from a label employee perspective? And then finally, they look at state privacy laws. This includes, well, the federal versus state authority, data privacy and security laws, and finally, the state data breach notification law. So this, as a reminder, this is just what the IPP is doing. If we move on to the next slide, these are the topics that we propose should be covered in terms of the CLA for the legal specialists. And there is a lot of overlap as well with the previous presentation. So the first topic we think should be in no specific order, of course. So the first topic would be cybersecurity and information security standards and best practices. So this is, we think a must in the sense that it is a requirement as well in the various data protection laws, including the CCPA, to have basic security standards in place. Data breach response, including state breach notification requirements. That is also another area which we think is quite standard, because it is something that all organizations should be aware of and what they should do in case the unthinkable happens. The third topic, AI and the processing of personal data. That is a relatively new topic, but then because AI has really permeated all industries, I would say, these days, and because it is being increasingly reviewed and implemented by organizations, we do think that how the use of AI may have an impact on privacy, on personal data. That is something which would be a very good topic that a privacy specialist will want to keep up with. Data subject rights as well. That's another an obvious one, because it is a requirement as well under the various privacy laws. Laws relating to access to information systems. So this would be in relation to the Stored Communications Act, the Wiretap Act, other anti-interception laws, another big and hot topic as well that a privacy specialist would probably want to stay on top on. What are the different requirements in terms of privacy policies and practices, children protection, and so forth, age verification, another big and important topic. Frameworks related to privacy and data security, such as ISO 27001, the payment card industry data security standards, and so forth. So these frameworks, because they are being more and more used within organizations, they should also be something that a privacy specialist consider as well when they want to review CLEs to listen to. Moving on to the next slide. We have direct marketing rules, including CAN-SPAM Act, do not call requirements, international privacy compliance, including other US state privacy laws, the EU or UK GDPR, international data transfer requirements, financial privacy, including the Gramm-Leach-Bliley Act, other federal and state financial laws, health information privacy, including the Health Information Portability and Accountability Act, HIPAA, educational privacy, including the Family Educational Rights and Privacy Act, state laws governing student privacy and education technology, employment privacy law, information technology law. So all of those topics, we think they are quite high level, without being too specific on, specific, technologies or whatever. But at a high level, we think these are the top topics that should be included in the list of CLE topics for the legal specialist.
Thank you, Paul. I have I have a procedural question for the staff, and Paul, I think my understanding, please clarify this for us. This is meant to be the legal specialist continuing legal education. So we're not talking, this is not the exam, the daily topics for eligibility. This will be after you have been you have received certification, right?
Yeah, absolutely.
Okay. And so Adrian and Janelle, procedurally, what is our task here? Our consulting group, we're putting together, in the last year or so, we've been working on the exam topics. So, we have a list of exams that we have proposed, and we're going to be discussing them and approving them in the next October meeting. This is after you have passed the exam and after you have been certified. These are the topics that we are suggesting could be topics for the continuing legal education. Is this set in stone? Because we talked a lot, when we were talking about the exam topics, we talked a lot about how the longevity of it, right? So I think we decided at that time, at least for the exam topics, to shy away from specific laws because we did not want to have to revisit, and to the extent that laws get amended or repealed or changed, we want to talk about it more at kind of a descriptive themes rather than specific laws, because we thought that we might not want to, or we may not get to change exam topics frequently. Is LSCE topics, is this the topics that we could change and update frequently, let's say annually, for example?
I mean, if we needed to, we could, but
what would it
I guess
take
it would
to
just
change it?
it would cause confusion for applicants. Like, oh, this counted last year, but now this year it's not counting.
What would it take? So if we want to, so let's say today, these are the 15 topics that we vote, right? And we want to change, how does this get presented to the applicants? Is this going to be presented as part of our privacy law specialization process? And it'll say that to be an approved LSCE provider, it has to be one of these topics, right? To be providing an LSCE credit. What would it take for us to change if we wanted to update, let's say, one of these topics?
I guess it would be providers or applicants. They're saying, hey, there's this new subject. It doesn't fall under any of these categories. Can we add it to an acceptable category or add it so it can be counted? And then it'll go to the CBLS to approve, to consider and approve.
It has to go back to CBLS. Who would accept the change? So, would one of us, and is there, I guess, another, like, how would you receive feedback like that, in order for us to change it? And what is the process? I know that there is a calendar, you have to get on the, meeting and whatnot. Does this also require change at the Board of Trustees level or just the CBLS?
I believe this would just be CBLS. So it'll be similar to how this committee was established. They're saying we should explore it. So the CBLS reviewed it and they decided that we needed to explore it.
Yeah. Okay. So my question to Paul is, to what extent did you think about how these topics, LSCE topics, should draw from, talk to the exam topics? Do you think there is a relationship between the exam topics and the continuing legal education, or were you really thinking this is something that is separate?
I think it can be separate, right? Because the person may have taken the exam a few years ago, and then he was doing a list of topics which we think are still relevant this time. So there is necessarily going to be some connection, because of course there is going to be some overlap. The topics would be the same, but then it doesn't necessarily have to be identical forever due to that. And this list here are just high level topics which we think are relevant today, but then who knows as well, maybe in the future we may need to add new topics as technology evolves and so forth. But then we try to make it relatively high level to avoid having to update this every year.
All right. Any questions or comments for Paul? Okay, I'm going to ask a question in a slightly different way. Do we like these topics? Do we want to add any topics, or do we want to take away any of the topics? So we got 2 slides here, and I think we have about maybe a dozen or so here. So do we agree that this is the full list of the topics that we want to have presented? Knowing that it'll take some time, right? And probably a lot of administrative work to get them changed. We know as privacy lawyers that the law is constantly changing. So I think you're right, Paul, that we want this to be high level enough that it'll hopefully withstand the test of time, at least for a few years. I think that's the goal. So is this comprehensive enough, but maybe specific enough to give the LSCE providers enough guidance? Michael?
Yes, thank you. I think it's already stated, but I'll just restate for completion's sake at this point. As you know, technology changes and just making sure that things do adapt accordingly. For example, if you had this like say 5 years ago or more than 5, cryptos and whatever stuff will be on it. If you ask that like 2 years ago, it'll be NFTs or whatever scam that was. At this point, it's just continuously changing and ebb and flow of stuff. So as long as it's adaptable, I'm all for it.
Thank you, Michael. Any other comments? Brian?
I just want to say that I like the list. I like that it has privacy adjacent topics on it, that folks who are really specializing in an area of privacy law ought to have the flexibility to kind of do a deep dive on those things. So I like that we have financial, health, educational, employment. I like the list.
I pulled up the exam topics. So again, I'm kind of trying to think about this holistically as a package, right? And all the different subparts of it that we have been working on. So if I recall, we for the exam topics, we have broad topics, things like professional responsibility. And then we have themes like data collection, emerging technologies, to Michael's point, was a topic. And then we, work through to say, here are the subtopics within those larger themes. Would you, Paul, I like listing out specific laws because again, I think it gives some color to what we mean by it. But, if I were to look at a crystal ball, HIPAA is probably not going anywhere. HIPAA is probably not going anywhere. FERPA is probably not going anywhere. However, do you think we should, how strongly do you feel about including those references to the specific laws? So for example, I think we could see the topics being one level up. So you could say financial privacy, health privacy, educational privacy, versus including, right, the specific callouts like GLBA, HIPAA, et cetera. Do you feel strongly that we should include references to specific laws as examples of the big themes, the big topics?
I don't feel strongly about it, but then again, it depends, I guess, on the specific topics, right? Because, for example, in relation to international privacy compliance, if we don't give any examples, then people will be wondering, well, do I need to know what, whatever's happening in the Middle East or whatever, right? So it does help to a bit limit the scope But other than those fringe cases, I do think that we don't necessarily need to have the example in the other cases. Those were just for illustration purposes. It does help the reader to get a better sense of what is expected, because sometimes if you just say, well, educational privacy, full stop, well, would everyone necessarily think, oh, we have to look at not only the federal law, but we have to look at any state laws and so forth? Well, maybe we do think that the privacy specialist should be should know that, but then not always, right? So it does help, I think, for everyone to have a better idea, but I don't feel strongly about keeping the examples if that causes any concern.
Mhm. Thank you, Paul. Just to be clear, I'm looking at, it was really helpful for me that you set out in the beginning, what the requirements are. So us as California licensed attorneys, we have MCLE requirements that are 25 hours in the period of 3 years. If we were to be to be approved as a privacy law specialist, we're going to have 36 hours in that same time period, I believe. So what we are talking about here is the list of topics from which we could draw 36 hours of continuing legal education. And for technical purposes, Adrian, what that means is if I do 36 hours from one of these privacy specialty area in the last 3 years, we would automatically meet the regular MCLE requirement, because 36 is more than 25. So it's not 36 plus 25, it's 36 in the specialty area, right?
Well, plus those 7 subfields that Paul mentioned.
Correct. Yeah, that's true. The 7 subfields, such as ethics, competence, etc.
And then also,
okay.
You kept saying it's for recertification. So this would be for applicants for initial certification. They need 45 hours in the 3 years preceding submission of that application. So those applicants need to also know what courses to take.
Say that again. So I thought this was for recertification. So
applicants, it'll be the same for recertification or initial. So applicants for initial certification, they have to report compliance of 45 hours of privacy law specific courses.
Oh, I see.
In the 3 years preceding submission. And then once they're approved, it becomes 36 hours every 3 years.
Oh, so when you say recertification, it is just the very first time. So talk through this with us. Is the recertification, so there is the approval, the first application, and then there is recertification. Is recertification happening within the first 3 years after you are? No, okay, explain it to us.
There's just generally there's 3 requirements on 3 different schedules for active certified specialists to meet. So they have to pay the annual fee every year, billed on the same time as their annual fee statement. They have to report 36 hours of LSCLE. This is done every 3 years at the same time as your general MCLE compliance. And then you have to recertify every 5 years. And this is based on the date of your initial certification. So if I got initially certified today, 8/29/2024, I would have to recertify again in 2029. But I think that compliance group, I'd be compliance group 1, that's going to be in 2 years, I think it is. So, and I have to pay the annual fee next year. So there's different schedules and different requirements that you have to follow.
Got it. I'm going to just say it back to you, make sure I understood that correctly. So after you are certified, you're going to have the 36 hours every 3 years. So in the same reporting period where you do your MCLE reporting, you would have to show 36 hours of LSCLE. Okay. Outside of that, in addition to the 3-year reporting that every California licensed attorneys do, you will also have a recertification that happens every 5 years from the date of the certification. So you got 2 different reporting periods in addition to the 3-year, that MCLE reporting that we do for everyone. And in here, instead of 25, we're going to have 36 hours for the specialty credits. Plus, you have to show 45 hours every 3. Sorry, it's the recertification is every 5 years, but you said it's 45 hours for 3 years?
No, 45 hours is for just new applicants.
For the new applicants, okay. So very first recertification, which happens within the first 5 years of getting the certification, you'll have 45 hours, is what you're
No.
saying.
So after you take the exam and you're ready to apply,
Yes.
you have part of the application is you have to show 45 hours of LSCLE. So in addition to that task and experience, you have to
That's the
show 45
application. So this
hours.
is the application
Yes.
to be certified.
To get initial certification, yeah.
Got it. And then every 5 years, you have to do recertification,
Yeah, that's only task and experience and new references.
but not the continuing legal
No,
specialty.
yeah, because continues every 3 years. But let's say I'm not due to recertify until 2025 and I'm supposed to submit my education next year. If I don't submit my education next year, I'll lose my certification even though my term is 5 years because I didn't meet that requirement. Does that make sense?
Could
Yeah.
you say that
and then-
again?
Yeah, say that again.
So let's say I'm due to recertify in 2025,
Mhm.
but I have to report my education next year.
Mhm.
If I don't report my education next year, I will lose my certification, even though I'm not due to recertify until 2029, because
you-
I didn't
you
meet
have-
that requirement.
Because those are two separate. So you got the continuing, so you got the LSCLE requirement, which is 36 hours, in addition to the recertification, is what you're saying. Those are two different requirements, right?
Mhm.
Okay, and if you miss one, you lose the certification.
Yeah.
Even if you're not due to recertify. So
Yeah.
in terms of, and what you're saying is these topics that Paul presented would be used for all of those, for the ongoing every 3 years, 36 hours, and also the first set of 45 hours that are going to be due as part of the application.
Mhm.
I see. Is it clear to everyone? I see a hand from Michael.
There's a question about what if you conducting the panels or discussions on that? I understand that I can.
It follows the same general MCLE rule. So
Okay,
if
cool.
you're teaching, you can claim four times you're speaking, or 4 times the activity time.
Mhm.
Yeah.
So 1 hour CLE, if I teach it, I get 4 hours credit.
For the first time, but if it's like if it's a repeat series, only for the first time do you get 4 times. But if you're doing the same activity again in a month, you only get 1 hour.
If you're teaching the same CLE.
The same exact activity, yeah. So if it's like
Yeah.
if you're doing the same exact activity just on 2 different dates,
Mhm.
the first date you can get 4 hours, and then the second date you get 1 hour.
Got it.
Which is the same, which is the MCLE requirement as well.
Mhm. Okay, so thank you for clarifying that for us, Adrian. So these topics are not only for not only for well, first of all, I keep saying recertification. It's not for recertification. I think what you're saying is there is no there will be no continuing specialty privacy credit will not be requirement for recertification. Recertification will only have the tasks and the experience and references, right? The only time that this specialty CLE will be needed are during the application process, where you have to show that you've taken 45. I'm getting the numbers mixed up. Part of the application, you have to show you've taken 45 hours in the specialty CLE topics in the last 5 years?
3 years.
3 years. Although the tasks and experiences are looking at the last
5 years.
5 years.
Correct.
Okay, so those are different. So while the tasks and the experiences were looking at the preceding 5 years and up to the point of application, to meet the specialty CLE credit, part of the application requirement, you have to have 45 hours in the specialty topics in the preceding 3 years before the application. Plus, if you get certified, you have to continue to do 36 hours of the specialty CLE every 3 years at the same time that you do the regular MCLE reporting. Did I get that right?
Mhm.
Okay. So I think everyone agrees that this has to be broad enough, but give enough direction. Paul said that he's not 100% against maybe removing some of these, but maybe for some of these topics it is helpful to include some examples. I just want to revisit what you said about, let's say, the Middle East. Because these are topics, for example, if I want to do all 36 hours of my specialty credit in Middle East privacy law, I could, right? Adrian is saying yes. So, these are, again, I think meant to be the full range of topics from which LSCE credits can be provided. It does not mean that you have to do, going back to our earlier conversation, it does not mean that you are going to be forced to learn about education privacy, even if you do no work in education privacy. You can pick and choose, and you can choose to spend all 36 hours with one, or you can learn about all the different topics within privacy. Is that right? I see it not heading from Adrian. So I would like to start talking about the alternative to the exam, because we're now at the halfway mark with 30 minutes, unless anyone else has comments or questions about the specialty credits topics. Okay, we're going to move to the last part of our business, which is business agenda item 3C. So we're going to be discussing the review of our research, and this is Ryan and I presenting on a potential privacy law specialist alternative to examination. And if you can go to the next slide, we want to kind of explain what that means. When the State Bar begins a new program, and just to again, full circle, remind ourselves that the California State Bar has, I think it has been decades since the last time the California State Bar has created a new specialty. So we are so excited and honored and privileged to be working with the State Bar in creating this new specialty. And we have really been on a journey together to talk about why the specialty is needed, and how the specialty could really benefit the legal community for California. So while this specialty program is going to be approved, and if everything is approved, then at the next CBLS meeting, we will have a decision by CBLS to allow for the specialty program to begin. Then we will begin the exam drafting process, and that might take some time. So this is a process by which the California State Bar has allowed new specialty programs to approve experts, specialists in specific areas to get approved and to become specialists without having taken the exam. And so Ryan is going to be presenting to you, here are some thoughts that we had, that the two of us had, that this list of suggestions, which we would welcome feedback from the group, could replace the exam. And what that means is, instead of the exam, meet these criteria. You still have to meet the specialty CLE credits, which we just talked about. You still have to meet other application requirements, but this will replace the exam. Only for the first 2 years, right, Adrian? So what that means is, after, let's say, this specialty is approved and we can begin announcing the application process to have begun, let's say that's January 1, 2025. It is only for the first 2 years that the exam will not be needed, and you can get certified without having passed the exam. And this is only for the very first, what I'm going to call an introductory offer for the specialization. Any questions about the process? We will go into discussion about what could replace an exam for the first 2 years. Everyone clear in the process? I don't see any raised hand. So Ryan, if you could present to the group for us what we thought could be the set of experiences and tasks that could replace an exam for the first 2 years.
Yeah, thank you, Juwan. So yeah, we met and discussed some alternatives. to the exam requirement for those 2 years from the approval date. The suggestions we have are on the slide, but we weren't suggesting requiring all of them. And we wanted to discuss what combination of this could be appropriate or what other additions we ought to have. So to run through the list, we have providing a description of ongoing and substantial involvement in practicing privacy law, which would be at least 25% of full-time practice over the 3 years preceding the application. I'm kind of rethinking number 2 here after a discussion we just had about CLEs, but supplying evidence of at least 25 hours of continuing legal education from the topics in the privacy law specialist exam specifications within the 5 years preceding the end of the 2-year alternative exam period. Providing at least 5 peer references from attorneys, clients, or judges attesting to privacy law qualifications. Supplying evidence of privacy certification from an industry recognized certifying body. And then teaching a 2 or 3 unit class substantively related to privacy law or related topic, or at least twice at an accredited institution of higher education. We suggested credit for teaching may be used for purposes of satisfying these alternatives or satisfying continuing legal education requirements, but not both purposes. So those are the suggestions we came up with. I feel like adding 25 more CLEs onto the CLEs that were just described, I don't know what we're at that, like.
Yeah,
wanting,
I'm
like,
not sure
68
that
or
we were
something.
thinking about in addition to, right?
Yeah.
I don't think I understood until today that part of the application would be to show the 36 hours of the specialty CLE. So Ryan, I'm rethinking. I mean, again, to explain for the public's benefit, these suggestions were presented, without having consulted the rest of the other, presentations. It was also presented, without the benefit of today's discussion. So I feel like we could probably remove item 2 from the suggestion, right, Ryan?
I mean, otherwise you're gonna have close to 70 CLEs you'd be turning in.
I don't think we meant, in addition to, right? And I'm not sure that really solves, what we're trying to get at. If you had 36 hours of specialty CLE in the preceding 3 years, plus you had another 25 years, does that mean that you don't have to pass the exam? I don't think so. I'm not sure that really kind of comes to replace an exam. I think that the CLE portion we were thinking was part of a larger, way of replacing the exam, but I see that there is already a 36-hour, application requirement.
Yeah,
So I would withdraw removing and suggest removing 2 from the alternative exam proposal.
I agree. And I'm wondering, do we also have a peer reference requirement elsewhere?
Yeah, that was going to be my next question. So could you clarify for us, what is the entire application package? So let's start with the exam because that's what most people will do. And then let's talk about what's going to happen for the first 2 years. So for the, once this is going and, 2 years after this has been established, what would be the entire application package? One is the exam. What are the others, Adrian?
Yeah, so in order to get certification, you're right. So applicants, they have to take the exam. And then once they're successful on the exam, they can apply for initial certification.
Okay.
So that's going to be the task and experience within the 5 years preceding submission of the application. 45 hours of LSCLE within the 3 years preceding submission of the application. And then at least 3 references.
Okay. So the references also is already in the application. So maybe it doesn't make sense. I guess revisiting number 3, maybe it doesn't make sense to ask for 5 peer references if getting 3 references is already it's a different part of the application for certification.
Could they be overlapping references? Like since we're replacing the exam requirement, asking for 5 is just a little bit more than what we would already be turning in.
So the regular application would have asked for 3. If you're not doing an examination for the first 2 years, basically ask for 5 instead of 3. So it's number goes up. That's an idea.
Adrian, are they able to ask for clients as a reference?
No, we typically want legal professionals, judges, other attorneys that applicants have engaged with that are familiar with the practice.
So clients could be lawyers.
I guess, yeah. I mean, if your client's another lawyer, yeah.
Okay, but you're saying it has to be a legal professional in terms of references.
Typically, that's what we look for.
Got it. So let's say, and going back to some of the ideas that Michael had presented, let's say you are very involved in a bar association. Getting a reference from Adrian, who is not a lawyer, would not work. Adrian is saying no. Okay, so it is, so we would have to say it's a reference from a legal professional. Does it have to be a legal professional that's licensed in California or just licensed to practice anywhere? Licensed to practice anywhere. I'm just repeating.
They should always, they need to be familiar with your practice. Like it can't just be any attorney and,
sure.
Yeah.
Sure, but let's say your client is an IT specialist because you do breach response. That would not work because your client is not a lawyer. But the general counsel who oversees the IT specialist could, for example. Okay, because maybe we can come to the other ones, but I'm not sure. I'm not sure if let's talk about the other ideas and maybe we just have to come back to the group and come up with other ideas. So imagine for the application. So let's go to, we talked about how there's an exam and you got the task and experiences and you got the LSCLE, the 45 hours requirement, and then you still got the 3 references. That's after 2 years of having established this specialty. Now, the day that this is approved from CBLS, we're going to open this up for application and we're going to forego the exam. So, think about for the first 2 years, who do you think, we would be able to assess that they have the requisite expertise, that they have excellent excellence level and not just competency level of being a privacy law specialist. So we're going to allow a number of specialists to be approved and certified as a privacy law specialist without having taken the exam. And they still need to show tasks and experiences. They still need to show that they have taken 45 hours of CLE, specialty CLE in the last 3 years. What else do you think this applicant needs to show without having taken the exam to prove that, to demonstrate that they have the requisite level of experience? That's the task at hand. Question to the group, is there anything else that we could ask to add as an alternative to examination than we have here on the page? While we think about it, again, because we were preparing this without having the benefit of the other 4 teams, I'm wondering about the first item as well, because showing a description of the ongoing and substantial involvement, that I think that was very similar to, I think, what we ended up discussing, which is a task and experiences. I'm not sure. In addition to showing the task and experiences, what more description of ongoing and substantial involvement we could ask from the applications? I feel like item number 1 is duplicative or quite overlapping with the task and experiences.
If I may, you could look at number 1. So I guess depending on how you want them to report their task experience. So if we're going back to those 4 groups and you say you only need to report, the additional can be like, oh, I meet 2 of these groups, or I meet 3 of these groups. Or if it's point-based, you say the applicants must have a minimum of 100. Let's say an applicant says they have 200.
Okay. I see.
Yeah.
Okay, so make it slightly harder. So
Correct.
here is the, okay, that is a good idea. So maybe this is kind of going back to Arsen's point, right? Is that because we don't have the benefit of the exam for the very first 2 years, we would have to show that this person is an expert and is ongoing and substantial. And so while the application process with the exam would satisfy with a checklist, maybe the first 2 years alternative examination, we will require a little bit more, right? Maybe we'll ask for more task and experiences. Maybe we'll ask for more descriptions that are more qualitative than just a checklist, because we don't have the benefit of the exam to test the core expertise. Okay, so it sounds like we could keep, we could still keep item number 1 here, and we would have to think through, because in the next meeting, we will have discussed, here is what the task and experiences look like for the application. Then the alternative to examination could really be talked about, discussed at the same time. We can say, if this is the list of task and experiences for the application, this is what we would ask for the first 2 years from the specialist. We could really kind of put 2 and 2 together. Okay, so I'm hearing, unless there is a disagreement, we will keep number 1 and we will revisit after we have agreement on what the task and experiences will be for the application itself. Everyone agreed on number 1? I see heads nodding. Okay, number 2. So I had suggested, because application already is going to ask for 45 hours of specialty CLE, I was withdrawing our suggestion number 2. I don't think it makes sense to do the 45 plus 25. I think Ryan was saying maybe we should. So maybe we should, especially if we're an expert and we're teaching them and you're getting 4 hours of credit, instead of 1. Maybe it is reasonable that you would have done, let's do the math. So 45 plus 25 would be 70. So no, is that the level of CLE maybe? So regular applicants would have done 45 hours of specialty CLE. But if you're going to forego the exam and you are going to be certified in the first 2 years of the specialty being approved, you would show 70 hours of CLE. Is that the suggestion on the table? And what do people think? Is that the way to kind of, again, to Adrian's point, asking for something more because we're foregoing the exam?
I think that's really high.
Really high. Even
I
for,
agree.
Yeah,
it's really high, and it really seems burdensome. I mean, yeah, that's my opinion.
yeah. I think that's right, because I'm keeping in mind Paul's presentation, right? Because when we announce that this specialty has been approved, from that moment, we'll be looking backward, and really without this specialty requirement, we only asked for the regular MCLE requirement was 25, right? So, I think people would have done 25 in the last 3 years. And so I think already asking for 36 within the same period is a lot, and adding another 25 seems almost impossible. For me, is there any other opinions on removing? Is there any strong opinions to keep it, let's say? Because I think we heard some comments to remove it. I think so far we've had 3 voices saying remove number 2. Remove the additional CLE requirement. Anybody want to keep it? I don't see any hands up. Okay, we're gonna remove the CLE requirement and keep it to the 36 specialty requirement, which is part of all applications. Number 3, so for that, I think I heard that maybe it does make sense. So instead of 3, again, peer references, meaning it has to be from lawyers, is the clarification that we received. So the regular application process will ask for 3. For those who are foregoing the exam, we'll be asking for 5. So slightly more to be able to show that you have kind of broad support, I would say, in terms of the peers acknowledging your reputation and expertise. Thumbs up, thumbs down. Do people like keeping the reference requirement and making it higher for those that are not taking the exam for the first 2 years?
I think this is reasonable, but we worked on this list together.
I just
Mhm.
can I add a little point of clarification?
Sure.
So they have to receive 3 positive references. So it's not it just simply providing the name isn't sufficient.
Sure.
Yeah.
So it's in support of. It's
Yeah.
really you're looking for support letters, right?
Correct.
Yeah, meaning we're gonna say you need 5 peer references, and if we get the copy of the letter and the letter says like, meh, this person is really not an expert,